Are you aspiring to ace the UPSC CSE? Commence your transformational journey with the Vision IAS Delhi GS Foundation Course 2025. Empower your exam preparation through cutting-edge educational technology and personalized learning experiences with tech-enabled learning. Dive into concepts with animations, videos, and interactive tools designed for maximum understanding and retention. Personalized student portal. Access live classes, recorded sessions, and extensive academic resources, all at your fingertips, anytime, anywhere. Enroll now and step closer to accomplishing your IS dream. With the Vision IS Delhi GS Foundation Course 2025, batches starting from 31st August, 5 p.m., 17th September, 9 a.m., 24th September, 1 p.m., 30th September, 5 p.m.
Good evening, all of you. Okay, yesterday the questions that we discussed yesterday were easy questions. Okay, so now today the entire discussion has been divided into parts. So yesterday we were doing Indian Constitution and related things. Being honest, most of you sitting in the class, even if you have prepared on an average basis, then also you will be able to answer. Today we will see those questions where most of the students get their answers incorrect. Why? Because because of the non-availability of prime sources. Okay, so for example, you have Indian Constitution. So most of the questions have already been asked, and there is a standard prescribed source. Okay, you have Vision IS material, you have M. Lakshmikant, you have other textbooks also where you read so you don't make mistake. If I'll start asking from article 1 to 395, you will not make mistake. If you have done, because by the time you will appear for prelims, I know your psyche, you will cover those books 2-3 times. So you will not make mistakes. But when it comes to governance, here you will make mistakes most likely. Why? Because tell me one source. Getting my point? So the source one, sometimes it appears in Press Information Bureau. Is it echoing? Voice is okay? Okay. Echo? Okay. So sometimes it appears in Press Information Bureau. Some schemes are appearing in newspaper. Okay. Then you will get a PDF available of all the schemes. Okay. But you will not memorize them. Why? Because there are 50-70 schemes. It is practically not possible. So please understand 2-3 basic things. One, these questions, if UPSC, I'll show you, I have gone through the question, of course. So this actually before also we have discussed 5 years many a times. Okay, only 2024 we have added. So but there are many things which keep changing. Some new question has been added, so there is a correlation and all. So how will you will answer these questions? Here you will yourself feel that you don't know. But yesterday the kind of questions we were discussing, those were the topics where you yourself will feel that you know it. Okay. So first you have to read newspaper very, very carefully. Any scheme which is reoccurring. Okay. So if it is reoccurring time and again, then you have to make a note by yourself, because this is abstract. This is abstract. If they're asking a question, what are the major provisions of Right to Free and Compulsory Education Act? you, even if you are prepared with diligence and some sincerity, you will get the Right to Free and Compulsory Education Act PDF, and you'll. But if I'll ask how Right to Free and Compulsory Education Act is being implemented in India, then you will not get, because it is purely a dynamic thing which is given in a in newspaper or annual status of education report. Yeah, students get trapped. So then there are, but you go through it, see, over the period of time, when we see the questions year for last 10-15 years, okay, if you include everything, so you understand the psyche. First, they will not ask a scheme or a policy which is never in news. So of course, Government of India may be running centrally sponsored scheme many in number, center sector scheme many in number. So they will not ask a scheme which is not very prominent. They asked Atal Pension Yojana, Gati Shakti Yojana. So those schemes they will ask which is in news. Second, they will give an impossible statement. Jaise some key terms that UPSC, first, if you analyze the question paper, you will understand the minds of UPSC. So they will use the statement that it is a well established practice. It is a well established practice. So examination में you know कि this kind of extremely polar statements are always incorrect. It is completely excluded. It is completely excluded. It is always practiced. Getting my point? So if there is an extra word, I'll show you those questions. I have gone through them today also. So then it means that it is a trap, because they give you those statements which are impossible in nature. They give those statements with too much what you call affirmation. Getting my point? Ki those statements which are 100% wrong, but they will present them in such a way that it will appear that it is absolutely a correct statement. So those statements which are actually right, they may create a set of ambiguity, but those statements which are actually wrong, usme bahut zyada, it is a well established procedure, always there will be this. So all these things means second. Third thing, I'll show you some questions where UPSC has asked a very easy question, but they have asked a question very easy, but they have framed 4 options which are very, very confusing. So if you, and they are so comprehensive in nature, so elaborate, कि once you read immediately in the examination hall, you will skip that question. Let's leave that question, because this question seems very voluminous and time consuming. So I will not attempt this. I will not waste time. But if you will read that question, it is the easiest question in the exam. So what UPSC is expecting you? First, it is the point that you have to, what you call, this is an elimination round. So you, in the entire prelims is there are so many students who are well prepared, but they every time they fail in prelims. Reason being that prelims is a mental game. Prelims is a pure mental game. It is purest form of mental game, where you have to be mentally agile in the examination hall. First. Second, how will you get what you call confidence? When you start practicing papers, okay, then you tend to get practice. But let me be honest, the questions that are asked in test series give you a very standard understanding, but they are not always the kind of questions that are asked by UPSC. Whatever you get in the test series, of course they are very standard questions, but many questions or some questions would be there. So even if you're not getting very good marks, you should not panic. Before any test series, first thing that should be done is previous year's question paper, because UPSC is not asking that hard a question. Now how this discussion will help you regarding information. So information, already there are zillions of sources available where previous year's question is discussed. But as a teacher, my job would be to bring an interdisciplinary approach, that why they have asked, what is other aspect related to that topic. Second, to let you understand the psyche of UPSC over the period of time. Now, over the period, not completely, but to a large extent, I have understood if UPSC is asking this question, what is it their psyche behind asking this question. Even without reading the option, I will say that this option they have framed, even if I don't know the fact, I am also a human being. If they're asking any corner scheme which, because I teach polity and governance, but every single scheme which is coming, I go through newspaper, whatever is possible. But there may be one, two things that also can solve by just going through the question, because over the period of time that experience comes ki, okay, there UPSC is going to trap you on this. So all these things will come once you will practice ample of papers. Up now, what is the thing? UPSC ensures that there will be areas conventional questions would be there. So first thing, UPSC knows very well that if we are asking conventional questions, then everybody will answer, because most of the student, even the most insincere one, he will also prepare for 2-3 months before the prelims, and he will also be able to. But those questions which are asked from newspaper, okay, so those questions, so you will practice, you will read newspapers very carefully and eliminate those which is not required, and practicing papers in a conditioned atmosphere. If you practice paper like whenever you feel like, you see, nah, that is not a practice. If your exam is 9 to 11 a.m., this is one suggestion, you may follow or not. So if you are practicing paper 50 questions a day, then you will not leave anywhere except very, very urgent thing. Otherwise you will sit, you will practice 50 questions. If you keep doing this from January or whenever you feel like, then you will get conditioned in the examination manner, and then examination will become a cakewalk. So to develop that mental grit, you have to practice paper, and in between you should not be allowed to leave. If you have decided that you will practice 50 questions, you will do that. That will prepare you for the real time examination. And then honestly saying, abhyas will happen. You will get exposed to the real time thing. So prelims mein sirf facts are not important, and the problem lies where students are making mistake, those facts which are not prescribed in the standard textbook. Jaise, give me a textbook for IR. Give me a textbook for IR. So all whatever textbook you will get for IR, there will be many questions which will be dynamic in nature, which has happened recently, and books are updated after a while. So current affairs material will be very, very handy in them. Some new questions, for example, they frame a question that how Indian diaspora has become the cultural ambassador of India. So from the cultural perspective, or you can say, how do you think that there is the social capital of the country gets eroded with the flight of intellectual capital? Getting my point? So the flight of the people who are smart, and they are leaving the country, which a brain drain, we call it brain drain. So with the brain drain, so all these questions which you will not find in a conventional textbook, which UPSC has framed on its own, and they expect you to answer. Reading newspaper carefully, and everything honestly saying which the teacher mentions. For example, I'll give you one example, then we'll start. Whenever in all the classrooms, whenever you teach zonal council, you teach States Reorganization Act, and Home Minister is the chairman of all the 5 zonal councils, and chief ministers become vice chairman by rotation. This is taught, and at the end it is mentioned that there is a Northeastern Council also under Northeastern Council Act 1971. This is mentioned, and there are 8 states in Northeastern Council. Now what UPSC did, they knew that everyone has already prepared zonal council, and they asked Northeastern Council, where Home Minister is not the ex officio chairman. So there will be hardly any question which has never been mentioned. So when in any class, there is always a paucity of time. So even if you, so those things which are casually mentioned also, it will take hardly 5 to 7 minutes every day that you will go through that. I'll give you second example. In every class, it is said that there is a flag code of India mentioned on the website of Ministry of Home Affairs. And bus. If you start teaching the flag code also, then it will take ample of time. Then every topic will take 1 year. So if the teacher mentioned flag code of India, then you have to immediately go. Those things are being asked which are mentioned, which are related to that, but you have ignored that. And last year they asked the length and breadth of the national flag, which most of the students got incorrect, although knowing that there is a flag code of India. So smart people who make some effort on their own, who not only rely only on the current affairs, which is a standard material, but also on things that are appearing in newspaper. And finally, those who use internet extensively. So if any topic is being discussed, a law is being mentioned, then you have to, any personal maternity benefit act hai, so what was the changes, what implications, whether it has brought some changes or not. So ye student jo karega, anywhere you are taking classes, anywhere on earth, you have to make efforts on your own also, because if every law is being discussed, then it will take 5 days to complete just one topic. So whenever something is mentioned, you should make your own efforts also, then only you will be able to what you call do this. Yesterday we have done till, I remember, these all things we have not done. Okay, this also we have not done. These all things we have not done. These are easy. Some questions are easy, but later on, those governance questions would come, and they are more important. Now we will discuss what are the tricks also which UPSC is employing. These things we have not discussed. Just a second. This also we did not discuss. This also we did not discuss. I think this we discussed. So we will, this also we discussed. Then we'll start from here. Okay. Now they have asked a question that right to privacy is protected under which article of the Constitution of India? This doesn't even require explanation, because you know that privacy is, the Supreme Court in case Puttuswamy versus Union of India case ruled that right to privacy is an inherent part of Article 21, first point. Second, what possible questions tomorrow UPSC can ask? That right to privacy is not an absolute right in India, it is a qualified right. Third, what are the reasonable restrictions? Reasonable restrictions are it can be curtailed by a legislative mandate. There must be a law for a proportional cause. See, I am saying right to privacy is not absolute in India. We are not United States of America, where fundamental rights are relatively more absolute. For example, if we see American Supreme Court judgment Texas versus Johnson, the American Supreme Court has ruled that burning the flag of America is the freedom of expression of Mr. Johnson. So in Texas versus Johnson, it ruled that even burning the flag is a form of fundamental right. But our fundamental right in Article 19(1)(a) has restrictions in 19(2) of the Constitution. So our fundamental rights are not that absolute. Reason being simple. Our country laws are based on our socio-cultural setup. America has 34 crore population. India has 140 crore. America is multiple times bigger than India, and India is relatively smaller in geographical area. So can America dare to have a small area with 140 crore population and such diversity? It is only, or it can say it is the beauty of India, where 140 crore stays in a small area, and that too with such diversity, and still we are becoming strong every day. So our laws cannot blindly copy United States of America. So they have relatively absolute fundamental rights. Our fundamental rights are relatively more restricted, which must be restricted in a reasonable manner. So right to, tomorrow they can ask a question on right to privacy. What question? Ki bhai, right to privacy is restricted. So one, whenever you are, for example, you are tapping someone's phone, so that is a violation of privacy. So right to privacy can be violated subject to 3 conditions being fulfilled. First, it should be backed by a legislative mandate. It should be backed by a legislative mandate. So there was a law, Indian Telegraph Act 1885, that empowered the Home Secretary to order the tapping of phone lines. Now that law has been replaced by another law last year. So don't wait for UPSC to ask that law. You have to go through the important provisions of the new law. So first, it should be backed by a legislative mandate. It should be for a legitimate cause. Laws should promote a जब भी किसी की fundamental right to privacy violate हो रही है, it must be sanctified by a law. The law must be for a legitimate purpose, and most importantly, doctrine of proportionality. The law must be for a proportional cause. Proportional cause means कि for example a bicycle theft happened in the society, you cannot check everyone's mobile phone or start tapping phone to for, because the cause for which you are invading someone's privacy must be proportional to the thing. You cannot kill an ant with an howitzer. आप तोप से एक चींटी की की हत्या नहीं कर सकते. So when your fundamental right to privacy is being violated, it must be sanctified by a law. Law must be for a legitimate purpose and must be proportional to what is the means you are going to, what is the end that you are going to achieve by invading privacy. That end must be proportional to the invasion. Okay, so you cannot invade privacy. We are not America. There is an open case that in an iPhone related to a terrorism in America, the Federal Bureau, the central agency of American government, like we have Central Bureau of Intelligence and Investigation, entry 8 in the union list is Central Bureau of Intelligence and Investigation. Similarly, CBI kya hai? CBI is the agency, Federal Investigative Agency. So it is the agency of the federal government, that is the central government. So it is not an agency of state government, it is an agency of the central government. So America, it is Federal Bureau of sorry, in America there is Federal Bureau of Investigation. Okay, Federal Bureau of Investigation means it is the investigative agency of the federal government, not of the state government. So in India, what is the agency, investigating agency of federal government? Central Bureau of Investigation, and there is an entry in the union list, entry 8, Central Bureau of Intelligence and Investigation. This why I am mentioning, you will know. America, there an incident of terrorism happened. So the Federal Bureau of Investigation requested the Apple Incorporate to unlock the iPhone. Apple said no, we will not unlock the iPhone because privacy is an important component of our phone, and our entire business model functions on that. So in there, the right to privacy is relatively more sorry, right to privacy is relatively more absolute, यानी उसमें restrictions कम है. इंडिया में right to privacy comes with restrictions, that it can be restricted by a legislative mandate, by for a legitimate purpose, and it must be proportional. Whatever steps you are taking must be proportional to the end that you are trying to achieve. You cannot check everyone's mobile phone just merely because a bicycle theft happened. So there must be a big reason for invading someone's privacy. Now this question, third, UPSC can very conveniently ask a question about the data, that general data protection, that law which was passed last year, one of the most important laws, how the data, who is the data fiduciary. What I am saying, not that I am too intelligent or something, but it is very likely that I am mentioning data fiduciary. Next you will find that in prelims पेपर. कोविड कब आया? 2020 में. यूपीएससी ने 4 साल बाद, आफ्टर 4 years, यूपीएससी asked a question that interstate quarantine is union list subject. So COVID came, there was a quarantine in 2020. Now they asked a question in 2024 that quarantine is a subject in the union list. So many a times UPSC doesn't ask something which happened that year. They will ask after 2-3 years when you have forgotten the same. Okay, so general data protection, what are the provisions, what is the new law, what is the new law replacing Indian Telegraph Act, information technology rules. I am not asking you to memorize the law, it is foolish to do that. You must know the important provisions, and you will find all these things literally on Vision IS currently, that is monthly current affairs related to the respective one. You have to read that. Okay, one more thing, some important laws. I always, yesterday also I said, but many new students have come, so yesterday also I said some important laws have to be, what you call, you go through them and go through the important provisions. Okay, so this question, right to privacy, this now I don't expect UPSC to ask. This question was asked in 2021, but 2022, 20, or this will be the easiest question in the question paper, because almost everyone will get this question correct. So if you are getting this question incorrect, then you are of course losing. If you are getting this correct, then you are at par with others. You will be above others if you get more questions correct, and especially those questions which students are not getting correct, then you will beat the, because if 5 lakh students are there, 4 lakh to समझिए बस ऐसे ही 1 lakh student of 50,000 में competition होगा, they all will get this question correct. So you have to answer one such 2-3 things. One, all those questions which are easy in nature, you are not allowed to make mistakes in those. Second, Second, questions which are factual in nature, or what you call, which is something interdisciplinary. The moment you answer one such question, you are jumping the queue, and those conceptual questions, so you will get it. So those questions actually decide that whether you will be inside the list or outside the list, because almost everyone appear in the prelims, he doesn't even need, he will straight away go and say Article 21, that is right to life, includes right to privacy, but it is not absolute in nature. So now it says this is one of the easiest question in the question paper. But what UPSC has done, they have given 2 lakh pages description to confuse you. इसमें कुछ भी नहीं है. Even if you don't read this, you just read discretionary. एक word पढ़ लिया, discretionary. You know Article 14 calls for reasonable classification. Article 14 is salt. Okay. Anything, if you will download 100 cases of Supreme Court on PIL, in 95% of them, any other rights being violated, 25, 26, 29, 37, कोई भी right violate हो, they will also mention Article 14, because every action of the state should be reasonable in nature. So if women are denied entry into Sabrimala temple complex, into a Sufi shrine, right to die with dignity, right to privacy, kuch bhi ho, even right to environment, abhi 3 months back Supreme Court ruled that violation of environment is also what you call is a violation of Article 21. Right to clean environment is of course covered under 21, but also under Article 14 of the Constitution. A few months back judgment has been given कि the right to clean in or a healthy environment is also protected by Article 21 as well as 14, because if somebody is polluting and because of him somebody else is getting, because of the pollution set by certain people, the entire mass is suffering, and there is no equal access to environment, free and healthy environment. So it is also a violation of Article 14 of the Constitution. So अब ये कह रहा है, I have said this, ऐसे भी going by the going by the option you will eliminate. Article 44 is uniform civil code. Article 28 is that the nature of education in India, the no all 28 clause 1, that all those institutions that are wholly financed by the state, shall not impart. Article 28 clause 1, that the educational institutions that are wholly financed by the state shall not impart religious instruction. Article 28 clause 2, that nothing in clause 1 shall be applied to an educational institution that was established by an endowment or trust but which requires religious instruction to be imparted. So Article 28 clause 1 matlab Central University of Hyderabad, IIT, JNU, Delhi University, who are wholly financed by the state, will not impart religious instruction. Clause 2, those madarsas and all which were Vedic Pathshala mentioned in Right to Education Act, those which were established to impart religious instruction, उनको बनाया ही गया था मजहब की तालीम के लिए. So those institutions that were established to impart religious instruction, if they impart religious instruction after being administered by the state, then the restriction of clause 1 will not apply to them. Then clause 3, that any person who is attending an institution that is either receiving aid, help, or even recognition from the state, they will not impart religious instruction without the consent of the person, and if the person is minor, by his guardian. So Article 28 to ऐसे ही पता, it is related to secular nature of education in Indian universities. Article 32 is gate, right to constitutional remedy. It is the gate to enter Supreme Court, and it is the medicine, not the disease. Here they are asking the disease. And then Article 44, everyone knows that uniform civil code. So Article 14 would be the correct answer, that every law should be reasonable. The principle, now Supreme Court says classification is permitted as long as it is reasonable. So Article 14, so a law which confers on the executive or administrative authority an unguided and uncontrolled discretionary power. This is a clear-cut violation of the principle of reasonableness under Article 14 of the Constitution. Reasonable classification in manner application of law violates which of the following articles? It is Article 14 of the Constitution. So option would be A. Now under the Indian Constitution, this is an easy question. Concentration of wealth. ये question क्यों easy है? सबसे पहले concentration of wealth कहाँ है? Article 39C, that the operation of economic system in India should not result in concentration of wealth. This is Article 39 small letter C. Then Article 39B and 39C are always in news. Next year also I can say they are going to ask a question on 39B and C. I cannot be 100% sure, but this year also they could have asked a question on 39B and C, because article ye question you should not make mistake. If you are making this question as a mistake, it means you have not studied well, because this is Article 39C directly, that operation of economic system in India should not result in concentration of wealth. So 39C is a directive principle. So under the Indian Constitution, concentration of wealth violates not the right to equality, not the right to freedom. Getting my point? 25 to 20. So you see the important aspect related to religion and expression also. Concept of welfareism, that is different. So it is directive principles of state policy, especially Article 39B and C is always in news, because 39B and C is mentioned in Article 31 capital letter C of the Constitution. Crux is, any law that seeks to implement 39B and C shall not be held void for violating 14 and 19. I am again saying in Hindi then in English, कोई भी ऐसा law जो आर्टिकल 39B और 39C के उसूलों को इम्प्लीमेंट करने के लिए लाया गया है, उसको अनवॉइड इसलिए नहीं घोषित किया जाएगा कि वो 14 और 19 को वायलेट कर रहा है. सो बेसिकली आर्टिकल 14 और 19 को सुपरसीड करती है आर्टिकल 39B एंड 39C. नाउ आई एम रिपीटिंग इन इंग्लिश. एनी लॉ दैट हैज बीन इनैक्टेड to implement Article 39, you need a law to implement many articles. I have said this in class and zillion times. You need a law to implement many articles. For example, Article 17 says abolition of untouchability. तो सजा क्या होगी? The punishment is given in Protection of Civil Rights Act and SC/ST Prevention of Atrocities Act. Article 21A says right to free and compulsory education in the manner state may determine by law. So what will be the teacher pupil ratio? What will be physical punishment? School management committee, what do you mean by free? What do you mean by compulsory? What is the what you call capitation fees will be levied or not? All such things are written in Right to Free and Compulsory एजुकेशन एक्ट 2009. सो कई बार एक आर्टिकल को इंप्लीमेंट करने के लिए एक लॉ लाने की जरूरत पड़ती है. मेनी टाइम्स यू नीड एन ऑर्डिनरी लॉ टू इंप्लीमेंट एन आर्टिकल ऑफ द कॉन्स्टिट्यूशन. जैसे आर्टिकल 23 बैन्स इमोरल ट्रैफिकिंग बॉन्डेड लेबर. सो क्या पनिशमेंट क्या होगा? व्हाट विल बी द पनिशमेंट? दैट इज गिवन इन इमोरल ट्रैफिक प्रिवेंशन एक्ट, bonded labor system abolition act. Now no child below the age of 14 years shall be allowed to work in a factory, mine or hazardous employment. What will be the punishment? It is given in Child and Adolescent Labor Prohibition and Regulation Act. Article 42, the state shall provide just and humane conditions of work and maternity relief. Pregnant women will be given maternity relief, so you need Maternity Benefit Act. So you need a law to implement an article of the Constitution, क्योंकि everything cannot be written in the Constitution, so you need an ordinary law. So any law that seeks to implement Article 39B and C, 39B and C के principles को if a law is implementing, it can violate 14 and 19. In simple language, although 31 was also there, if you read the 42nd Constitutional Amendment Act, okay, anyways, I'm not going into that. 31 तो अब delete हो चुका है. Article 31 is not there. 31A, B, C is there, but 31 is not there. 31 has been deleted. So what is the present status? Any law that seeks to implement Article 39, Article 39 B and C shall not be held void for violating Article 14 and 19. So 39 B and C has a primacy over 14 and 19. So अब चलो ये तो I expanded the question. Otherwise concentration of wealth. अब Article 38 में कल ये पूछ दे. 38 में it is written that the state shall minimize inequalities in income and eliminate inequalities in status. अब गौर से सुनिए. 38 में कह रहा है the state shall minimize inequalities in income and eliminate inequalities in status. In 39C it is saying operation of economic system should not result in concentration of wealth. So 39C में कह रहा है that the economic system should not result in concentration of wealth. और 38 में कह रहा है minimize inequalities in income. So tomorrow they may ask which of the following articles provide for minimization of inequalities of income. Then the answer would be Article 38. How will you? अब इन चीजों में you are not allowed to make mistake because these are pure facts which are given in the constitution, you have to go through it. Okay, and article 12 to 51, so of course you must go through the constitution also directly. And getting my point, so I will settle for option B, directive principles of state policy. Now, what is the proposition of right to property? Again, a question which created a lot of debate. Sabse pehle, everybody in the class, even the panwala in the whole Rajendra Nagar knows that right to property has been shifted from fundamental right to a constitutional right under Article 300, capital letter A of the Constitution. First, second thing, that when right to property was in Article 19(1)(f), only citizens enjoyed that, because Article 19(1) says all the citizens shall have right to. So 19(1)(f, जब right to property एक fundamental right थी, then it was available only to the citizens. When right to property become a constitutional right, now they are saying no person shall be deprived of his property save by the authority of law. This is Article 300, capital letter A of the Constitution. So if there is a question, the applicability scope of right to property has exceeded after amendment? Yes, because 19(1)(f) was available only to the citizens, but 300 capital letter A is available to the persons, and persons also includes Infosys, TCS, SAIL, BHEL, GAIL. All these companies also are artificial person, and human beings are natural person. So no person shall be deprived of his property save by authority of law. So if you interpret it, no property of TCS, Steel Authority of India Limited, BHEL, GAIL shall be taken away without the authority of law, because person not only means human being, person means persons which are artificial, and artificial person is a company. The Supreme Court has ruled that Article 300, यानी Infosys की भी जमीन को बिना law से आप ले नहीं सकते हैं. So it is not confined to the citizens only, it is confined to the artificial person. अब चलिए, UPSC has the question that legal right available to citizens only. This you will eliminate if you know Article 300A. It says no person shall be deprived of his property save by the authority of law. So if you will see citizen, you will eliminate. Neither a fundamental right nor a legal right. Those who have just memorized that right to property is a constitutional right, then they will take, okay, this can also be an option. Legal rights are available to any person. It is a legal right available to any person. And then you have fundamental right available to citizens. So even a naive person will exclude A and C. Now you are left in the examination hall from B and D. That legal right available to any person. Now you must think, although it is tough to think if your concept is not clear, that nobody taught you legal right karke. They taught you statutory rights, Mahatma Gandhi National Rural Employment Guarantee Act. They taught you fundamental rights, they taught you constitutional rights. But one thing was said, rights are legally protected interests. So rights are those interests which are legally protected. So it is not that the legal rights, the constitutional right is not you cannot call it an illegal right. I'll explain something further. If you ask me what is law, there is a difference between act and law. Act is made by the legislature. Law कुछ भी हो सकता है. First example, law made by parliament. Second example, law made by state legislature. Third, Muslims are guided by Muslim personal law. Fourth, in southern part of the country, you can marry cousins, and in many parts. Now this is a regional law based on custom. So law customary भी हो सकता है, law parliament के द्वारा भी हो सकता है, state legislature. Fifth, Vienna Convention, United Nations Convention Against Corruption, United Nations Convention on Elimination of All Forms of Discrimination Against Women, UN Convention on Refugees 1961. So Paris Climate Agreement. Law can also be an international law. Law can be a customary law. Law can be a law made by parliament. Law can be a law made by. So law is a very, 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 very generic term. Ab jaise some communities, they do not marry in the same gotra. That is very common. So this is not a law made by parliament. This is a law that is a customary law. So Article 13 mein Supreme Court has ruled in Sabrimala case that the term law includes the custom, and it is written also all those customs having the usage of law. So all rights are legal rights. They are not illegal rights. So it is wrong to have this as a choice. You will settle for Article 22B. Now what tomorrow UPSC can ask? These abhi kuch din pehle, you were reading newspaper before 2 months, suddenly a new debate started. Supreme Court ने कह दिया कि Article 31C has to be interpreted in contemporary light. For example, कि अगर if tomorrow Tesla comes to India, okay, and Tesla comes to India, invest $500 billion, okay, they construct a factory, this, that, tomorrow the state takes over the property. You know, state can reserve any business for itself, it can take over, no person shall be deprived of his property. So Supreme Court says ki now that socialist tenor, so Supreme Court is examining whether Article 39C can be used to take over the property of a private person. So they say at that time when these provisions were incorporated, there was a socialist tinge. But now the provision is कि अगर हम इतना strict provision रखेंगे तो हमारे यहाँ investment नहीं है. So Supreme Court says that now we will interpret Article 39C in the light of contemporary investment, foreign direct. If Infosys will think that I will invest $5 billion and it can be nationalized anytime, then foreign companies will be apprehensive and wary, or shall be suspective, or shall be afraid from investing. So this new debate has started that whether Article 39C can, to what extent it says that the operation of economic system 38 does not result in Article 39C, that the operation of economic system does not result in concentration of wealth, and Article 38 that is minimize inequalities in income. So court अब examine करिए to, ऐसे भी Supreme Court has said that socialism is not the basic structure, welfareism is the basic structure. So this debate again is going on. This was the most probable question this time from Article 39 B and C and with Article 31 C. So we will settle for legal right available to any person because of the use of term person. Now this was a tricky one. This was actually first and third is nothing, Chintu. Second was a tricky one where most student made a mistake. Okay, so सबसे पहले that too you could have answered if you are getting your, you see that 3 is correct because quo warranto में there is no locus standi. All those who don't know locus standi is a principle which ensures that the person who has a legal injury only can move court. The लोकल स्टैंडाई एक उसूल है कि जिसको लीगल इंजुरी हुई है वही कोर्ट जा सकता है, कोई उसके बिहाफ पे कोर्ट नहीं जा सकता है. सो द प्रिंसिपल ऑफ लोकल स्टैंडाई सेज अ पर्सन हु हैज सफर्ड फ्रॉम लीगल इंजरी ही कैन ओनली गो टू कोर्ट, other people cannot go to court. Public interest litigation में principle of locus standi is waived. You can also go to court on the behalf of entire society. Now quo warranto, challenging the authority of a person holding an office and whether he is usurping a public office, he is not qualified. For example, many years back Central Vigilance Commissioner was appointed, some 12 years back, and the appointment was set aside by Supreme Court. सो अपॉइंटमेंट को लेकर कुछ लोग कोर्ट चले गए कि द पर्सन, वी आर नॉट गोइंग इनटू द फैक्ट्स ऑफ द केस, बट द पर्सन अपॉइंटेड नॉर्म्स वर नॉट फॉलोड प्रॉपर्ली. सो कोई भी इंसान जो पब्लिक ऑर्डर ऑफिस होल्ड करता है विच इज बाय अ स्टैट्यूट और द कॉन्स्टिट्यूशन, एनीबडी कैन मूव कोर्ट चैलेंजिंग, बट ओनली वन. नो को वारंटो कैन बी इशूड अगेंस्ट अ मिनिस्टीरियल ऑफिस. No quo warranto can be issued against a ministerial office because it will be violation of separation of powers. And classic example, multiple petitions were filed in Delhi High Court or other because some ministers who were continued to be ministers but they were in jail. Court said we cannot accept a quo warranto and remove them from office because quo warranto cannot be issued against a ministerial office, but it can be issued against any other. For example, SEBI chief was appointed some years back, then a petition was filed in Supreme Court. Then you have Central Vigilance Commission, there was a petition filed in Supreme Court. So किसी आदमी ने अगर कोई पब्लिक ऑफिस हथियार रखा है जिसको वो क्वालिफिकेशन मीट नहीं करता है तो कोई भी इंसान कोर्ट जाके उसके अपॉइंटमेंट को चैलेंज कर सकता है. एनी पर्सन हु हैज यूसर्प्ड द पब्लिक ऑफिस, if he is not fulfilling the mandate of the constitution or the law, any person can move court. जरूरी नहीं है कि उस ऑफिस के लोग ही जाए. It is not necessary that only the office will go, anybody. It means that the principle of locus standi will not apply. You also can challenge the appointment of SEBI chief or any CVC or Lokpal or any other. So any public minded person can be a petitioner to move court to obtain the writ of quo warranto. This is a correct statement. First statement, mandamus will not lie against a private organization unless it is entrusted with a public duty. This is always taught in the class. कि Article 12 of the Constitution defines the state. You have union governments and parliament, state government and state legislature. C में you have local authorities and D में you have other authorities, which Supreme Court in R.D. Shetty case, so many cases says कि if a private company is performing a public public duty, then it will qualify as what you state, otherwise it will not qualify as state. So this statement is also correct. Now this is wrong and this is correct. So 3 is wrong. So the 3 is right and 1 is also right. So we will see that all those options that do not have 1 and 3. So only 2 options we are left, either C or either D. So next, mandamus will not lie against a company even though it may be a god. This was actually a vague statement, because a government company most of the time is a mandamus will lie. But there are some companies which are not performing public function and government has certain stake in that. In some cases, Supreme Court has said that they will not qualify as state. So most of the students here opted for 1 and 3, and most of the answer keys also get. But UPSC took this statement as a correct statement, that mandamus will not lie against a company even though it may be a government company. Why? Because a government company who is not performing a public function, then mandamus will not lie against that. Getting my, if it's not performing a public function. So UPSC ने तीनों statement को correct मानते हुए D is the answer. Here if you make a mistake, I will not मतलब it is not something where you cannot make a mistake. Many students can make a mistake. So this is something where an element of subjectivity was there. Okay, now this is in essence due process of law. This question made the due procedure established by law and equality before law. This though we eliminate straightforward, because Article 14 में equality before law and equal protection of laws, Article 21 में procedure established by law. In American jurisprudence you have due process of law. So what is due process of law? Of course it is not procedure established by law, it is equality before law is under rule of law. Rule of law का बेटा है, उसका नाम है equality before law, predominance of legal spirit, rights. So ये दो तो हम exclude. Now 2, principle of natural justice and fair application of law, because it is said that due process of law is fair, just and reasonable. But fair, just and reasonable is already a part of principle of natural justice, which says 1, nobody shall be a judge of their own cause. 2, that everyone is entitled to a fair trial. That is 1, nobody can be a judge of their own cause. Everybody is entitled to a fair trial, सबको fair trial मिलना चाहिए. And odi alteram partem, you will always give an audience to the alternate party. यानी कोई भी फैसला सुनाने से पहले दोनों पार्टी की राय लेना जरूरी है. That is odi alteram partem. So principle of natural justice invariably includes in itself fair application of law. So fair application of law itself is a part of principle of natural justice, that is fairness in the trial. So we will go for principle of natural justice. There are many cases, we have time. So there are many, for example, 23 MLAs of don't write the party and all, just giving you an example. 23 MLAs of Aam Aadmi Party were disqualified for holding office of profit. So they were disqualified by the president, because in Delhi the chief minister is not appointed by LG but appointed by president, article 239 AA of the constitution. So many 23 MLAs of Aam Aadmi Party were dismissed for holding an office of profit. 23 MLAs moved Delhi High Court. So Delhi High Court said that whether they were holding office of profit or not, that is a different question. But when Election Commission of India was giving a binding recommendation to the president that these 23 MLAs should be removed because they are holding parliamentary secretary post, which is an office of profit, so they were not given an opportunity to present their views. कोई भी फैसला लेने से पहले इलेक्शन कमीशन को दोनों पक्ष की बात सुननी है. Before taking any decision, it must follow with the side A and side B. These MLAs were not given an opportunity to present their views, which is a violation of principle of natural justice, which says odi alteram partem. Odi means audience, alternate means altem, and partem means party. So you will only give a judgment after hearing both the parties. And then we have one more thing, that is ex party. अब कल UPSC पूछ दे ex party, EX space PARTE. Ex party एक rare order होता है. Yani, for example, there are two complainants in a case, and there is a civil case going on, and the other side, after repeated summons, is not taking part. Then the court, if the court issues an order after listening only one party because the other party is not cooperating, then it is called an ex party order, which is technically the court will try its best to follow the principle of natural justice, but if the person is not coming, then it is called, कई बार newspaper में देखेंगे court ordered an ex party, means they did not hear the other side due to multiple reasons, but generally odi alteram partem hoga, fair application of law, fair trial, and then nobody can be a judge of their own case, nemo debate karke, there is a principle. So I will settle for 24A. Now, according to the Constitution of India, central government has a duty to protect states from internal disturbance. This, if you don't know, then you should not download the admit card. Okay? Because this is directly given in Article 355 of the Constitution. That, see that Constitution mein diya hua, it shall be the duty of Union to protect every state from internal disturbance and external aggression and ensure that the state is being carried as per the provisions of the Constitution. ये कहीं पे कोई कंसेप्चुअल पॉइंट नहीं है, सीधा आर्टिकल 355 पूछा है. इट शैल बी द ड्यूटी ऑफ यूनियन टू प्रोटेक्ट एवरी स्टेट फ्रॉम इंटरनल डिस्टर्बेंस एंड external aggression and ensure that the state is being carried as per the provisions of the Constitution. Now, those who are already taking classes, if this topic has not been taught till now, then it is not your mistake. By the time if the topic will be covered, you will be acquainted. But if you have covered, you have done your classes and you are appeared for prelims and you have made this question as incorrect, then it is a crime. Why? Because यहाँ आपको मालूम होना चाहिए, this is pure basic fact, that is it is the duty of center to protect every state from internal disturbance and external aggression and ensure that the state is being carried as per the provisions of the Constitution, Article 355. Now, those people who confuse it with 352, the term internal disturbance have been replaced in 352 but has not been replaced in 355. So ये question कुछ भी नहीं है, चिंटू question है. This is statement is given in the Constitution. Now, Constitution of India exempts states from providing legal counsel to a person being held for preventive detention. बिल्कुल नहीं. A person who is detained under a preventive detention law shall be allowed to make a representation against the order as soon as possible and shall be informed the ground of detention unless it is against the public interest. So Article 22 does not prohibit the state from providing legal counsel. If you know I can say the language of Article 22 clause 1, every person who is arrested shall be produced before the nearest magistrate and shall be informed the ground of arrest. Second, it shall be allowed to consult a legal practitioner of their choice. फिर नीचे कहता है, nothing in clause 1 and clause 2 shall apply to a person who for the time being is an enemy, alien or a person who is detained under a preventive detention law. फिर नीचे कहता है, no person shall be detained in a preventive detention law for more than 3 months unless an advisory board has approved the detention further before the expiry of 3 months. फिर कहता है, a person under a preventive detention shall be allowed to consult the shall also be allowed to make a representation against the detention order as soon as possible and shall be informed the ground of detention, which will not be informed if it is against public interest. अगर सरकार को ऐसा लगता है कि आपको बताने की जरूरत नहीं है कि आपको क्यों डिटेन किया गया है, तो सरकार आपको उसका कारण बताएगी नहीं. लेकिन आप प्रिवेंटिव डिटेंशन में भी आपको रिप्रेजेंटेशन, उस ऑर्डर को चैलेंज करने का अधिकार है. So even in preventive detention you will be allowed to make a representation against the preventive detention order. So Constitution of India exempts the states from providing legal pure these. ये question आप exam hall में गलत करेंगे. Okay, which question you will make mistake? I know which question you will make mistake. This question most likely you will make mistake because of non careful reading of Article 22 of the Constitution. अगर आप अच्छे से पढ़ के गए होंगे 22 Constitution से, तब आप गलती नहीं करेंगे. If you have read it from any secondary source, then you will make mistake in this question. Okay, so state exempt, the Constitution does not exempt. So 2 is a wrong statement. ऐसा कोई exemption नहीं है. According to Prevention of Terrorism Act, confession of the accused before the police cannot be used as an evidence. Prevention of Terrorism Act का सबसे बड़ा ड्रैकोनियन प्रोविजन ही यही था कि एसपी और उससे सुपरिटेंडेंट ऑफ पुलिस एट अबव रैंक, if you make a confession against before them, it will be admissible. The law has been repealed in 2004. So this is also a correct statement. This is also a correct statement. But this question, most of the students will get it wrong. Reason being third statement. Reason being third statement, because Prevention of Terrorism Act, that is POTA, is something which is an old law you may not have gathered. So you don't expect UPSC to ask all the questions which you will know. There will be 1 or 2 questions which will be brutally factual in nature. इसमें chill करना है, ज़्यादा tension नहीं लेना, because if you are making mistake, AIR1 is also making mistake. Okay, so इसमें ज़्यादा ये नहीं है, ये थोड़ा पुराना fact था. This you should know, this you should know. Okay, so I will go for 1 and 3, so I will opt for only 2. Okay, in fact this question was a bit controversial also because they asked something which is usually not discussed. Now this is a question which you will answer if you have read Article 16 very what you call meticulously. It says the Supreme Court has held that in some judgment that reservation policies under Article 16(4) would be limited by Article 335 for maintenance of efficiency. ये pure fact है कि Article 16 Clause 4, nothing shall prevent the state from providing reservation in favor of backward classes of citizens who are not adequately represented in the services of the state. फिर से कह रहा हूं, Article 16 Clause 4, nothing shall prevent the state from providing reservation in favor of backward classes who are not adequately represented in the services of the state. Then Article 335 says कि while granting reservation, there should not be a compromise on efficiency of administration. इसीलिए किसी भी कैटेगरी से आप हैं, एक मिनिमम तो क्वालिफाइंग मार्क्स होता ही है, so as to maintain the efficiency of administration. So this is a correct statement. Now it is giving a, this also you will answer if you have read carefully. Article 16(4) and Article 335 is say two sides of the same coin. Article 35 mentions efficiency in administration, but it does not define. तो कह रहा है आर्टिकल 335 डिफाइंस द टर्म एफिशिएंसी ऑफ एडमिनिस्ट्रेशन, नहीं डिफाइन नहीं किया, सिर्फ एक अमेंडमेंट बाद में जुड़ा है, वन अमेंडमेंट दे हैव एडेड लेटर कि रिडक्शन इन द क्वालिफाइंग मार्क्स और ऑल सच रिलैक्सेशन विल नॉट मीन दैट द एफिशिएंसी ऑफ एडमिनिस्ट्रेशन इज बीइंग डाइल्यूटेड, बट दे हैड नॉट डिफाइंड द efficiency of administration. ऐसे भी as a student the kind of question they are asking, article 366 is the definition clause, all the definitions are there, so you should read the article 366 of the constitution जहां सारे definition दिए हुए हैं, who is an Anglo-Indian, who is a scheduled caste, read with article 341 of the constitution. So ये statement wrong है क्योंकि efficiency and administration mention तो किया है पर उसको define it has not been defined. So statement 1 is correct and 2 is wrong. So we can easily settle for option C for Calcutta. This was not a tough question. This you have to get it right. That the term secularism, untouchability, efficiency of administration, socialism, what you call term law in Article 13 was later explained. Socialist, welfareism, these are mentioned, but they are not exhaustively defined in the, what do you mean by minority? This question has been asked many times, has not been defined in the constitution. So I'll easily settle for option C for Calcutta. Which of the following, now this is the Supreme Court of India, right to privacy. Again the same question has come. Right to privacy is a part of Article 21, and right to marry also one question UPSC has asked, which is 21, and yesterday I discussed that also. Now here, a writ of prohibition is issued by Supreme Court or High Court to a government officer. We have already read that prohibition is issued to a lower court to prevent it from exceeding its jurisdiction. For example, NDPS court is examining a murder case. So Narcotics and Psychotropic Substances Act 1985 does not empower them. A Prevention of Corruption Act court is examining a murder case. That they are doing beyond their jurisdiction. So a government officer prohibiting him from taking a particular action? No. Legislative Assembly passes a law on prohibition. This is blatantly wrong because it will be violation of separation of powers. Lower court, the High Court to the lower court prohibiting the continuation of proceeding in a case, government prohibiting from unconstitutional policy. B and D is conveniently eliminated. If you have an understanding of separation of powers, C is the correct answer, because you should understand what are the 5 writs, then you will get it correct. So 28 I'll settle for C. There are some students, I'm just mentioning, they will make mistake just because of one reason, because they think too much, and UPSC doesn't require you to think beyond. The moment you will think something more facts will come and you will make mistake. So you are not supposed to go too deep, otherwise every word can be eliminated by some or the other thing. So you have to think what is mundane in a mundane manner. Now this is a Chintu question. Why? Because this is directly mentioned in the preamble that we the people of India do hereby solemnly resolve to constitute India into a sovereign, socialist, secular, democratic republic where justice dash social, economic and political, liberty of thought, expression, belief, faith, worship, equality of status and opportunity, and among them all, fraternity and assuring the dignity. So they, if you, unity and integrity was added later. So liberty of thought, expression, belief, faith, worship. So liberty of thought, expression, belief, faith. So there is no term like so I'm sure that most of the students who have prepared will get this question correct. That is one ka will settle for B. This was an easy question. Okay. Now this is a question which UPSC has taken directly from a Supreme Court judgment. Supreme Court judgment, time and again in Golaknath case and before also, Supreme Court has said in order to understand the minds of the makers of the constitution, you must refer to preamble. ये सुप्रीम कोर्ट का जजमेंट है एंड दिस इज मेंशन्ड इन सुभाष कश्यप बुक. ओके, एंड आई डोंट रिमेंबर एग्जैक्टली वेदर इट इज मेंशन्ड इन लक्ष्मीकांत और नॉट, but this class mein to of course it is said that in order to understand the minds of the makers of the constitution, we must refer to preamble. Okay, so option A would be the correct option. Now this is an excellent question. इसके लिए दुनिया की कोई किताब जरूरी, this is a common sense question. This is a common sense question that when we see equality, for example, the school is distributing chocolate boxes, okay, or boxes of snacks, and the school gave one student who is the close friend of the monitor, he got 2 boxes while other students got 1 boxes. So this is a violation of principle of equality because he is given some privilege. अब कह रहा है what do equality in the society is an absence of ideology. Matlab, in India there is equality, it means there is no ideology. So ideology has nothing to do with equality, although there can be an ideology that promotes equality. So you will easily eliminate. Competition. Do you think those countries which practice equality, there is no competition, then why is there competition for civil services? So competition is something to find the competence, it has nothing with equality. Then it says absence of restraint. ये तो next level गलत है. Imagine the society without absence of restraint. Just close your eyes and think that there is no restraint. If there is no restraint, you are going on the road, you will slap someone that okay, go and cut your hair. Then you will go and you will take 2 samosas from a shop and move. So there is a restraint. No society in the world can exist without a restraint. हाँ, ये बात है कि liberty is responsible use of freedom under rule of law. I explained this for 1 hour in the class कि liberty में इसी का same, इसी सगा भाई इसका पूछा है. एक one more question which UPSC has asked, that UPSC has, liberty is absence of restriction or develop oneself fully. The answer was develop oneself fully. क्योंकि liberty doesn't mean absence of restriction. If there is no restriction, then he will play music till 3 a.m. in the morning. If there is no restriction, he may slap someone whom he doesn't like. If there is no restriction, you may start cheating in the examination hall. So if there is no restriction, anyone will murder anyone. So liberty is responsible use of freedom under rule of law. Liberty is not absence of restriction. The liberty is absence of unnecessary restriction. Restriction होगा, पर वो restriction होगा जो जरूरी है. For example, the state makes a law that nobody will wear white on Monday. Now this is not a necessary restriction, this is an unnecessary. तो restriction होना जरूरी है, पर वो restriction चाहिए जो necessary हो. Restriction is good, but liberty is not about absence of restriction. Liberty is absence of unnecessary. If the state makes a law that nobody will speak after 6 p.m. Now this is not a necessary exception, this is an unnecessary exception. If state makes a law that nobody will murder anyone, now this is a necessary restriction on you. You may think that I have the liberty to kill anyone, but your liberty is responsible use of freedom under rule of law. So absence of restriction is not liberty. Liberty का मतलब ये नहीं कि आप कुछ नहीं भी कर सकते हैं, because liberty is not absence of restriction. Liberty is absence of necessary restriction. So there will be no unnecessary restriction, but there will definitely be unnecessary restriction. So it says equality in the society means there is no restraint. In the society, if there will be no restraint, then it will lead to a chaos. Getting my point na? So there is no competition. Ye bhi galat hai. So in the examination hall, this was an easy question. But if you will read it, of course I am saying, after a year discussing in air conditioned room, okay, so it is very, very easy. But if you will keep your mind absolutely positive and cool, you will get these questions as correct. Otherwise you more, and these are the questions those students very commonly you will see saying that thoda sa se chhut gaya, जैसे कि हमें कुछ क्वेश्चन आते थे, we knew but we made a mistake in the, that is what is being tested in the examination hall. They know very well that out of 4 lakh students, at least 50,000 are serious ones. Okay, so if those serious ones are on that way, you are not supposed to make small mistakes. You will make mistakes, but the less number of mistakes you will make, you will qualify. So examination hall mein ye easy question hai bhai, ki absence of ideology. Can there be no ideology in a society? Absence of competition. How will we select civil services people without competition? Absence of restriction. So if there is no restriction in the society, then everybody will start behaving in their own manner. So there is an absence of privileges. यानी किसी को कोई स्पेशल प्रिविलेज नहीं. बट ऑफ कोर्स अब इसी क्वेश्चन को अब आप जो स्कूल ऑफ थेथोलॉजिक्स जो इंपॉर्टेंट स्कूल है वहां से जो बिलोंग, ही विल सी कि हाँ रेस्ट्रिक्शन तो है, आर्टिकल 361 ऑफ द कॉन्स्टिट्यूशन, no case shall be registered against the governor or the president in exercise of their official duty. For personal matters, civil case can be registered after giving 2 months prior notice, and criminal case cannot be registered against governor or president till that time they are holding public office. So it means that there is a restriction, there is a exception to principle of equality. All those diplomats who are staying in Chanakyapuri, कोई डिप्लोमेट ऐसे ब्रॉड डे लाइट में गन लेके ऐसे शूट कर देगा, कुछ नहीं होगा. Because there is a Vienna Convention, सिर्फ हम बोलेंगे you leave within 24 hours. So some embassy people were involved in sexual harassment and all. सरकार ने बोला क्योंकि there is complete, उसमें भी level होता है, ambassador, high commissioner, they have highest level of immunity. In Pakistan what happened, there was a person of American embassy, a very famous case. There is a movie also, Reluctant Fundamentalist. Okay, so one person was in the American embassy or some, he saw a person coming. So he had this apprehension that this person will kill me. So he took a gun and immediately shot that person, who was an innocent person. But he had this confusion that if I will not kill, that person will kill. So in many, सबसे important case, Devyani Kharbhoje. So one of the IFS officers who were arrested, although she was enjoying, our respectable member of Indian Foreign Service was enjoying immunity, but still Americans arrested them before 11 years. So government came very strongly and America was forced to leave her. The case was dropped and she came to India because she was enjoying diplomatic immunity. तो मैं ये कह रहा हूँ कि Vienna, the equality also has certain exceptions. There are always exceptions. Okay, so we will see one of the अब ये question कैसे solve होगा? ये question solve होगा उसका जिसने जो खुश है, those who are happy. If you are stressed in the examination hall and if you are stressed in your preparation, you are most likely to make a mistake. There are students I know who go just prepare for 30 days. They are some old ones, and they go and every time they qualify prelims. Okay, so why? Because prelims के लिए your mental agility is you read all the books. Nobody is sure about prelims. Even toppers, if they're appearing next year to improve the service, they are also afraid about prelims, because prelims is pure, you will get an opportunity after 1 year. There is only 2 hours. The world is waiting to kill you outside the examination hall. If you make a mistake, there will be a lower self-confidence that iska to prelims. But it is not that so many students. So these kind of conceptual questions, either you don't attempt if you don't have an idea, akkad bakkad bambe bo, you will not do, or you will read NCERT class 11 political theory. Most of the time UPSC is framing one question. This question also is taken from there only. Okay, so class 11th की जो NCERT है, political theory, what do you mean by equality, what do you mean by secularism, what is the principle, all such things are given, and this question is lifted from there. So liberty is the absence, equality is the absence of privilege. जब privilege नहीं होगा तो everyone is equal. I'll settle for 3 का ये. Now this is in last 10 years, if UPSC has framed all the questions from constitution, I will rate this at top 3. This is among the best questions UPSC I think has ever framed. इसमें सिर्फ और सिर्फ कंसेप्ट छुपा है और कुछ नहीं छुपा है. This question is loaded with concept and conceptual clarity. Again, the person who slept well before prelims is most likely to get this question correct. Those who you see between 2 hours gap is there, especially during the main stage, somebody will call Tata 407, then they will have all the notes. Getting my point? And then they will read the notes so that in the last moment also they can add something. You have to be at peace with the whatever preparation you have. You will write fully if you have slept. You just sleep well and attempt a test series question, and you don't sleep and attempt, you will get that every time you will make 4-5 mistakes wrong, because if you are happy you will understand the concept. So those all things are also important. अब कहता है what is the relationship between law and liberty. कह रहा है if there are more laws there is less liberty. कोई जरूरी नहीं है. Law can be Motor Vehicle Act, law can be Code of Civil Procedure, law can be Indian Patent Act, law can be Geographical Indicators Act, law can be Central Vigilance Commission Act, law can be Income Tax Act 1961, law can be Prevention of Corruption Act, law can be Prevention of Insult to National Honor Act. जरूरी तो law can be Transfer of Property Act, law can be Law on Torts. इसका कोई मतलब नहीं है कि if there are more laws there is less liberty, because law can be in commerce also, law can be for civil matters also, law can be for property, for marriage also, Special Marriage Act 1954. So there are so many laws. So ye koi zaruri nahi hai ki if there are more laws there is less liberty. If there is liberty, laws has to be made by the people. If there is liberty, laws have to be made by the people, not necessarily that if there is a liberty, law technically we practice in direct democracy, it is made by the legislature. There is no referendum. First thing. Second important thing, there are so many places where you have ample of laws, but to have judiciary is not constitutionalism. For example, if in North Korea or any country anybody commits theft, he is not taken to the king. So there is a judiciary even in North Korea. But the difference between that judiciary and our judiciary is our judiciary is independent. Having a judiciary is not prerequisite to democracy. Having an independent. UAE mein, for example, if you commit a crime, you will not be taken to king. There is a proper judicial system there also. But the judiciary is not independent. So judiciary होना लोकतंत्र की जरूरत नहीं कि होगा ही. ऐसी judiciary जो independent फैसले लेती है. So here if there is liberty, laws have to be made by the people, not necessarily, because this is more to do with democracy. If laws are changed too often, liberty is in danger. Again, this cannot be safely said that laws are changed. Law may be change of what you call related to Securities Exchange Board of India Act. If RBI Act is amended, will that lead to less liberty? It is not. अब ये ऐसे भी, if you read this line, if there are no laws, there is no liberty. राइट बोलने से कोई राइट तो आ गई आंसर की, तो आप तीनों ऑप्शन ही मैंने कह दिया तो आप तो राइट हो ही गई है, पर ये क्यों राइट होगा ये इंपॉर्टेंट है ना जी. Why it will be? Now please see, just imagine a situation where there is no law. There is no law. So Gandhi ji said rights and duties go hand in hand. If everyone is conscious of his duty, rights will not be far to seek. Rights and duties go hand in hand. If everyone is conscious of his duty, rights will not be far to seek. Article. So for example, he has a right to live in peace. He has a duty not to play loud music. He has a right to live in a clean environment. She has a duty not to pollute the environment. She has a duty to live in peace. She has a duty not to play loud music. So अगर किसी मुल्क में law नहीं है तो 30 सेकंड भी लिबर्टी एग्जिस्ट नहीं कर सकती है. लिबर्टी कैनॉट एग्जिस्ट इन अ कंट्री इफ देयर इज नो लॉ. फॉर एग्जांपल, इफ देयर इज नो लॉ, देन somebody will park his vehicle in the middle of the road and he will eat chocolate momos. An invention. Okay, so they will eat chocolate, so because there is no law. So can a country sustain for 5 minutes without law? So हम सबों की लिबर्टी डेंजर हो जाएगी. I have a liberty to live, there is no law, somebody will kill me. So why people are not committing murder? Also because it is an offense. It is an offense. So बिना law के liberty रह ही. So liberty is responsible use of freedom under rule of law. You have a liberty to play music, but you do not need to disturb. Some people, they don't carry headphones. They are so irritating in the flight, in the train. They will just watch. They don't even think that this is a मतलब देखिए इट्स मतलब ठीक है, आई वांट टू लिसन, तो मतलब इससे, बट देयर व्हाई शुड आई लिसन टू देयर what you call. So if you have a liberty, there cannot be a liberty without law. हम सबों की liberty खतरे में आ जाएगी, our all liberty will be in danger if you there is no law. For example, he has a liberty to live, then if there is no law, somebody may attack him. So you bought a new iPhone, there is no law, somebody will snatch it. So liberty cannot exist without a law. So if there are no laws, there is no liberty. And again, this is from class 11, same textbook they asked. So we'll settle for B for Bombay. Now in context, which of the following you accept as the most appropriate definition of liberty? इसमें liberty, now इसमें ये फिर पूछा ना, back to back liberty they are asking. So now protection against the tyranny of political rulers, ये कुछ एकदम कुछ कुछ भी लिख दिया है, मतलब इट इज लाइक कुछ भी. पॉलिटिकल रूलर्स नाम का कोई आपने लॉ में कोई टर्म पढ़ा? पॉलिटिकल रूलर्स. Okay, so there is, although you say this in common parlance, but there is no legal connotation coming from it. Legal connotation is government. Government is a set of people who have the authority to govern. What they do is governance. So government is a noun and governance is a verb. And don't want to go into definition, but UNDP has defined that governance is a neutral term. It can be good, it can be bad. The decisions taken by the government is governance. Now it says that most appropriate definition of liberty. It says protection against the tyranny of political rulers. It maybe the tyranny is not of a political ruler, maybe the tyranny of a dictator or any other who is not democratically elected or some other ways. So this is not even a worth point considering. Then it says opportunity to do whatever one likes. Opportunity to do whatever one likes. ये तो गलत नहीं, supremely. We cannot do whatever we like. Absence of restraint. Now this again is the same question. Liberty is absence of restriction. Which society can, if they would have added one word here, ऐसे करके, absence of unnecessary restriction, then the statement would have been correct. Absence of restriction means there is no restriction in the society. If there is no restriction in the society, then anybody will start doing anything. So it is absence of unnecessary restriction. So this is eliminated to develop oneself fully. और ये पूरा एक घंटे तक when we talk about liberty, I told you about positive liberty and negative liberty. Positive liberty is expansion of human choices to develop oneself fully. So the answer would be D for Delhi in question number 5. Okay. Then we say the preamble to the Constitution of India. Again a conceptual question. Preamble is a part of Constitution but has no legal effect. This is a correct statement. But what it is, we have to choose a statement which is most correct. Preamble is not a part of Constitution. उड़ गया. LIC of India case and Keshavananda Bharti case, Supreme Court said that preamble is a part of the Constitution. Preamble is a part of Constitution, has no, now preamble part of Constitution has same legal effect as any other part. No. So preamble is a part of Constitution but has no legal effect independently of other parts. इसको समझना पड़ेगा. For example, if the state makes a law that nobody will practice their religion, अगर state ने एक law pass कर दिया कि nobody will practice their religion, you will challenge that law in Supreme Court. You will say that this law violates preamble or this law violates Article 25. So even if the term secular is not there in preamble, then also India is a secular country. So if state makes a law that nobody will speak after 6 p.m., so you will not go to, you will challenge the law not for violation of liberty of thought, expression, belief, faith, worship, but you will say it is a violation of Article 19(1)(a). Preamble is just a philosophical document, a gist. So it has no, so India is secular, not because secular term is mentioned in the preamble. Even when it was not incorporated through 42nd Amendment that came into force on 3rd January 1977, even if it was not incorporated, then also the term, then also the idea of secularism was there in Article 25 of the Constitution. All persons are equally entitled to freedom of conscience, profess, practice and propagate. Article 26 of the Constitution establish religious institutions of their choice and administer them according to law. Article 27, no person shall be compelled to pay taxes, the proceeds of which shall be used for the promotion of any particular religion. And Article 28 clause 1, no religious instruction shall be imparted in an educational institution that is wholly financed by the state. So India is secular not because it is mentioned in the preamble. India is secular because it is provided in the constitution. So preamble has no legal effect independently of other part. This is also a correct statement and this is also a correct statement, but this is more of a करेक्ट स्टेटमेंट कि प्रियम्बल का सेक्युलरिज्म को शक्ति आर्टिकल 25 से मिलती है. सो प्रियम्बल हैज नो लीगल इफेक्ट इंडिपेंडेंटली, बट इट हैज एन इफेक्ट इफ द प्रोविजन इज देयर इन द कॉन्स्टिट्यूशन. और ये क्यों पूछ रहा है क्वेश्चन? This question is asked because one more question which has been asked by all the exams in the country, why preamble was adopted at the end. So preamble was adopted at the end. पूरा constitution बन गया. Last day they adopted preamble, which is the beginning of the constitution. Something which is the beginning of the constitution was adopted and enacted at the end. Reason being कि they wanted to give a message to the world कि preamble is, जो बातें इसमें लिखी गई हैं उससे related articles हमने constitution में डाल दिए हैं. So preamble was deliberately adopted by the Constituent Assembly on the last day to give a message to the world that this is not merely a philosophical document. The ideas that have been incorporated in the preamble have an article in the Constitution. So the legal effect to the preamble is not given by preamble being justiciable, but preamble deriving its strength from an article of the Constitution. जैसे equality of social, economic and political justice. So political justice largely by the fundamental rights, social economic justice by directive principles, liberty of thought expression, belief, faith, worship, Article 25, Article 19(1)(a), freedom of speech and expression. So justice, social, economic, political, equality of status and opportunity, Article 14 of the Constitution. So preamble को जानबूझकर deliberately preamble was adopted at the end because they want to give a message कि all those principles that are incorporated in preamble have already been incorporated in the constitution. उसी को यूपीएससी ने अपने से एक क्वेश्चन फ्रेम किया कि preamble is the part of the constitution but has no legal effect independently of other parts. So India is secular not because it is mentioned in preamble. India is secular because Article 25 says all persons are equally entitled to freedom of conscience, profess, practice and propagate, and nowhere in the constitution there is a official religion of the state. जैसे Bangladesh constitution Article 2A, it establishes a religion. Initially it was not there, it was added later. So many American constitution, you see the amendment first, the Congress shall make no laws disrespecting the freedom of religion. So there is a provision. So the theocratic or non-theocratic character of the state is given in the constitution. So this we will settle for 6D. Okay. Now here. Now this again is a wonderful question. The provision of 5th and 6th schedule is made to protect the interest of border states. Is it necessary that Karnataka, Kerala, what you call, or chalo theek hai, they don't have direct contiguous waters then international waters. If you see the sabse pehle Arunachal Pradesh, Nagaland, Manipur, Mizoram, then you have what you call Assam, you have Meghalaya, then you have Sikkim. Getting my point? Like this. So it has nothing to do with Gujarat. Jharkhand has a 5th schedule. Gujarat has a 5th schedule area. Is Jharkhand a border state? Is so getting not necessarily that only for a border state. Determine the powers and panchayats. Okay, not 5th. Bhaiya 6th schedule has autonomous district councils which are relatively very powerful bodies. This panchayats are nothing. Okay, I have taught also the 6th schedule you have autonomous district councils which have so many powers. So it has nothing to do with this. Determine the boundary between the state, protect the interest of scheduled tribe, which is a correct statement. Now if you don't know 5th schedule, 6th schedule, it is a very small topic but conceptual. 5th schedule presently is in 10 states. A small area within the state is carved as a scheduled area. The President of India declares an area as a scheduled area. Simply kuch nahi hai. For example, I am the governor of Gujarat. There is a small area in Gujarat that is inhabited by tribal population. So every year I will keep us, for example, there are 5 children. One of them are not very healthy. You need some support so that they also, everybody has an equal right. They are equally talented. They must be given opportunity. So किसी भी राज्य में एक छोटा सा area, झारखंड में, or for that matter, Chhattisgarh or any other, a small area, if it is a scheduled area, then governor will inform the president every year about the development of that area. So actually they are protecting the interest of scheduled tribe. And sixth schedule to bhai brahmast hai. There is no decentralization in Indian constitution other than sixth schedule. सिक्स शेड्यूल को छोड़ के इंडियन कॉन्स्टिट्यूशन में उससे ज्यादा डिसेंट्रलाइजेशन कुछ नहीं है, जस्ट ब्रीफली टचिंग. फिफ्थ शेड्यूल चिंटू, उसमें कोई उतने पावर्स नहीं है, गवर्नर विल टेक केयर ऑफ द. बट सिक्स शेड्यूल में फॉर एग्जांपल इस क्लास में इस स्टेट, दिस क्लास इज अ स्टेट, असम ले लें. So these we have given 1, 2 and 3. These are 3 autonomous district councils. The state government also has very less power related to these ADCs. ADCs elections is conducted, and those people who win a autonomous district council election, they can, from establishing school to hospital, from dispensary to road, from making laws on marriage, inheritance, divorce, all such property disputes, civil, all such fall in their domain. So ADCs are brutally powerful bodies, and they had to, because they have been living, for example there is a tribal community, they have a beautiful culture, they are living in the same way for ages, marriage is conducted in a particular manner. Why should the law on parliament apply on those areas? Getting my point? Related to marriage, because they have their own beautiful culture, so the parliament respect the diversity. So all these matters fall within. I don't want to go because ADC itself will take half an hour, so we have so many questions. So ADCs का कि autonomous district council basically fifth schedule से compare नहीं किया जा सकता है. Fifth schedule में you have tribal advisory council, that is already elected MLAs give advice on certain matter. But autonomous district council तो super powerful bodies हैं, उनके अंडर में सब कुछ आता है. So both, but ultimate interest is both must protect the interest of scheduled tribe. So we will settle for 1A. We'll take a break, don't worry. Which of the following is not a feature of Indian federalism? There is an independent judiciary. Independent judiciary is a most important feature of federalism. क्यों? Because if there will be a federalism, there will be a conflict. होना ही है. State of Texas versus American federal government of United States of America. State of West Bengal versus Union of India. State of Rajasthan versus Union of India. I teach in federalism also. चाहे अमेरिका का कॉन्स्टिट्यूशन पढ़ूं, ऑस्ट्रेलिया, स्विट्जरलैंड, किसी भी कंट्री वेर यू विल फाइंड फेडरलिज्म, स्टेट और सेंटर में कुछ ना कुछ डिस्प्यूट होना ही है. Then there will be a dispute between center and state, so you require an independent judiciary. So it is asking that which is not a feature of Indian federalism. This is actually a feature of federalism. Result of an agreement among powers have been clearly divided between center and state. Seventh schedule, war and peace, extradition, citizenship, naturalization and aliens, United Nations, railways, insurance, all these fall within the center. Public order, police, land, agriculture, public health, cooperatives fall in state. Then you have CRPC, CPC, IPC, marriage, wildlife, forest, weights and measures, all fall under the concurrent list. So power is divided between center and state. So federation units have been given unequal representation in Rajya Sabha. Unequal representation in Rajya Sabha is not a federal feature. So, but it said which is not a feature to Indian federalism. So Indian federalism में ये feature है या नहीं है? ये बोल रहा है कि Indian federalism में कौन feature नहीं है? तो क्या इंडियन फेडरलिज्म में ये फीचर है कि हर स्टेट्स को अलग? यूपी हैज 31 सीट्स इन राज्यसभा, दिल्ली हैज 3 सीट्स इन राज्यसभा, बिहार हैज 16 सीट्स इन राज्यसभा. सो ऑल स्टेट्स डू नॉट हैव इक्वल सीट्स इन राज्यसभा. सो एक्चुअली दिस इज अ फीचर ऑफ इंडियन फेडरलिज्म, बट दे आर आस्किंग व्हाट इज not a feature of Indian federalism. India is not United States of America. एक simple line, those who are, of course some of you I can see are from the class, but this is for everyone, कि you just remember there was no country like United States of America in the history. अमेरिका नाम की कोई कंट्री कभी दुनिया के इतिहास में एग्जिस्ट ही नहीं की है. इट इज इन 1776 यू हैव अमेरिकन वॉर ऑफ इंडिपेंडेंस एंड अमेरिकन कॉन्स्टिट्यूशन 4th March 1788, देन यू एस्टैब्लिश यूनाइटेड स्टेट्स ऑफ अमेरिका. पर इंडिया इज Bharatvarsha, you have what you call Meluha, you so many. So India, the concept of India, many even 2400 years later back, many kings have put almost the entire subcontinent under one rule. So concept of India is old. America तो अभी 13 colonies of North America. जब the Western European powers used to attack America and they used to what you call colonize America. So North America की 13 छोटी छोटी colonies को लगा कि if we will remain isolated, then they will again attack. So they signed an agreement and formed United States of America. So they established the central government so that that should be strong enough to repel any outside attack. So America बनना एक मजबूरी थी. They were fed up with the colonization, so 13 colonies came together. All the middle colonies of North America later joined. Now we have 50 colonies and Washington District of Columbia. The District of Columbia is the district where American capital is there. That does not come under any state. So Washington District of Columbia, that is Washington DC. तो पहले 13 colonies थी. Now we have 50. Some they bought from Russia like Alaska. Then there are other colonies also. So America बना है states के साथ में आने से. इंडिया कभी किसी इंडिया इज नॉट अ रिजल्ट ऑफ अग्रीमेंट बिटवीन बिहार, मध्य प्रदेश एंड राजस्थान, और फॉर दैट मैटर हिमाचल प्रदेश और कर्नाटका और केरला. द आइडिया ऑफ इंडिया इज ओल्ड. द आइडिया ऑफ इंडिया इज old. So it is a result of an agreement among the federating units. Yani this is a wrong statement. ये Dr. Ambedkar also said in the Constituent Assembly that India is not a result of agreement. That will why we will not use the term feeders. अमेरिका की स्थापना कुछ लोगों के आने से हुई थी. भारत की स्थापना किसी ने की. ये 2400 साल पुराना भी concept है. So the idea of India is very old, but there was no country like United States of America in the history of humankind. It was only because those small states came together and formed USA, just so that the federal government is so powerful that they cannot be colonized. All other matters fall with the state government. So answer would be D for Delhi. Okay, we'll take a break in 5 minutes. Okay. The question the following: the Parliament of India can place a particular law in the 9th schedule of the Constitution. This is Article 31B of the Constitution, that Parliament can place a 9th. हर शेड्यूल का एक करस्पॉन्डिंग आर्टिकल होता है. यू हमेशा रिमेंबर. फॉर एग्जाम्पल, who war and peace, can Bihar declare war on China? No, because war and peace falls within the domain of the union, not within the domain of the state. So war and peace, citizenship, nationalization, aliens, extradition, Central Bureau of Intelligence and Investigation, so many things fall within the center and some things fall within the state. तो जैसे, so if there is a union list है, तो union list में who will make laws? Central Parliament will make laws, you know that. पर सिर्फ union list दिया हुआ है वहां तो लिखा है this is 7th schedule, list 1 is union list, list 2 is state list, list 2 is concurrent list. By common sense you will not say कि अच्छा union list है तो only Parliament can make laws. This you cannot say by common sense. This is given in Article 246 of the Constitution. So every schedule must have a corresponding. Common sense से we will not conclude कि union territory है, union list है तो इसमें parliamentary law बनाएगी. Only this is common sense, but this is not. So Article 31B is the corresponding article of Article 31B is the corresponding article of 9th schedule. Article 246 is the corresponding article of 7th schedule. Article 1 is the corresponding article of 1 schedule. Article 75 is the corresponding article of 3rd schedule. Then you have Article 243, which is the corresponding G, which is the corresponding article of 11th schedule. Then you have the Article 164 and Article 75 mentioned 10th schedule. So these are also corresponding article of 10th schedule. So every article, every schedule also has a जैसे you have 8th schedule, 22 languages. It is mentioned in Article 344 of the Constitution that there will be a language commission where representatives from all the languages in 8th schedule. So every schedule also has a, although Article 244 is the corresponding article of 5th and 6th schedule. So every schedule has a corresponding article. So 9th schedule, the corresponding article of 9th schedule is Article 31B. So Parliament can add any law inside the 9th schedule. You know that such law will be open to judicial review for violation of certain fundamental rights or basic structure. IR Coel Ho case 2007. So the validity of a law in 9th schedule cannot be examined by any court and no judgment can be made. I know all of you know in the class that judicial review is the part of basic. Only 2 articles in the Constitution where judicial review is exempted. Article 262 of the Constitution, any law related to interstate water dispute can exclude the jurisdiction of Supreme Court. Article 329 clause 1 of the Constitution, that no law related to or order related to delimitation shall be called in any question in any court. So original Constitution has excluded the jurisdiction of judiciary in Article 329 clause 1. In Article 262 there are very less places in the Constitution where the judicial review is excluded. Otherwise, Minerva Mills case, Supreme Court ruled that judicial review is the part of basic structure of the Constitution. So this is a wrong statement and this is a correct statement. I'll easily settle for 3 ka A. These are easy questions. The 9th schedule was introduced by first Constitutional Amendment Act in somewhere around June 1951. After 15 months of Constitution coming into power, Nehruji introduced the bill. 9th schedule was added. First Constitutional Amendment Act added Article 15, Clause 4, added restrictions in Article 19, added Article 31A and 31B, and also added 9th schedule. So technically, the first Constitutional Amendment Act was not done by Parliament. This I have said in the class, those who are new, कि first parliament तो आई ही है May 1952 में. So May 1952 you have the Parliament of India. So for 2 years when elections were not conducted and constitution has come into force, the Constituent Assembly was functioning as the Parliament of India. So technically the first constitution amendment was not done by Parliament. It was done by the same Constituent Assembly, which is 1950 में constitution आ गया, दूसरे दिन election हो जाएगा. 1950 Constitution comes into force. Under Article 327, Parliament passed Representation of People Act 1950. From Kashmir to Kanyakumari, Arunachal to Gujarat, you have to prepare voter list. It will take 1 year. So what is now, everything cannot be written in the constitution. So पहले law pass हुआ RPA 1950. Who is a voter, qualification to be a voter, where you can challenge, electoral registration officer, what is the ordinary rest, सब law pass हुआ. Voter list बन गई तब RPA 1951. That what is the qualification to become MP, what is disqualification, section 8, what is the provisions related to electoral dispute. Then you have section 65, then 1662 right to vote, then you have 123 corrupt practices, you have 126 electoral silence, 126A exit poll. So election se related jitni matters hai, that is given in RPA 1951. So in sub mein time laga. So when constitution came into force, we waited for 2 years. Then the parliament came into force in May 1952. Till that time, the Constituent Assembly was functioning as the first parliament of India, and it made the laws. That is, so first constitution amendment was actually done by the Constituent Assembly. So कौन था 1951 में prime minister? So answer would be Jawaharlal Nehru ji. Okay. Under which schedule of the constitution can the transfer of tribal land to private parties can be declared null and void? अब यहाँ 5th और 6th देता, तभी कोई confusion था. Now they have not given 5th और 6th, तो इसमें कोई confusion का सवाल ही नहीं है. 12th schedule is 18 subjects for urban local bodies. 9th schedule has certain laws related to immunity and all those things. 3rd schedule has salaries and oaths and affirmation. Oaths and affirmation is the 3rd schedule. So answer would be 5th schedule. Good. First schedule में list of states and union territories. Second schedule में you have salaries and allowances. Third schedule you have oath and affirmation. Fourth schedule, which state will have how many seats in Rajya Sabha. Fifth schedule you have scheduled areas in 10 states. Sixth schedule you have autonomous district councils in 10 autonomous district councils are there. 3 in Assam, 3 in Meghalaya, 3 in Mizoram, and 1 in Tripura. 7th schedule you have union list, state list, and concurrent list. 8th schedule you have 22 languages. 9th schedule you have those laws. 10th schedule is anti-defection law. 11th schedule is 29 subjects for PRIs, and 12th schedule is 18 subjects for PRIs. So अगर यहाँ 5th और 6th देता, then the what you call the provision related to that, it is also, see, non-transferable of land to tribal ADCs also control all these matters, but here the answer would be B for Bombay, that is 5th schedule. Question number 5, B for Bombay. The Constitution of India defines basic structure as federalism. सबसे पहले, the term basic structure is neither mentioned in the Constitution nor any law. So इतना बड़ी, कितना देख रहे हैं, गलत बात को कितना decorate करके बोल रहा है. It is saying, giving a brutally wrong statement, but it is making it so formal that it looks as a correct. The Constitution of India defines basic structure. There is no such thing mentioned in the Constitution. We know this has come from Keshwananda Bharati versus State of Kerala, 24th April 1973. The Constitution of India provides for judicial review to safeguard the citizens' liberties, preserve the ideal. Or the term judicial review is neither mentioned in Indian Constitution nor mentioned in American Constitution. It is Article 13, Article 32, Article what you call 13, pre-post constitutional law, 32, right to constitutional remedies, 131, dispute between center and state, 132, appellate jurisdiction on constitutional matter, 133, appellate jurisdiction on civil matter, 134, appellate jurisdiction on criminal matter, 136, special leave petition, 143, advisory jurisdiction of Supreme Court, 226, writ jurisdiction of High Court, 227, High Court exercising jurisdiction over all courts within its what you call limit except the military courts. So judicial review तो constitution में mention नहीं है, पर judicial review का concept है. So this statement is also a wrong. पर ये इसको देखिए, इसकी चालाकी का next level, इतना formal statement है कि ये देखने में करेक्ट लगेगा कि द कॉन्स्टिट्यूशन ऑफ, कौन बोले हाँ कॉन्स्टिट्यूशन में तो भाई जुडिशियल रिव्यू होना कितनी जरूरी चीज है, इट्स सो नेसेसरी. द कॉन्स्टिट्यूशन ऑफ इंडिया प्रोवाइड्स फॉर जुडिशियल रिव्यू टू सेफगार्ड द सिटीजंस लिबर्टीज एंड टू प्रिजर्व द, उसमें और इंग्लिश जोड़ा है, प्रिजर्व द आइडियल्स ऑन विच कॉन्स्टिट्यूशन इज बेस्ड. बट दिस इज प्योर अ कॉनमैन क्वेश्चन. सम पीपल वर देयर इन अ स्कूल कॉलेज जो एकदम ज्यादा एग्जाम से पहले दे नॉट ओपन द बुक, बट दे विल से कि एकदम नर्वस कर देंगे कि वो पढ़ा है वो वाला थ्योरी, ठीक है ये तो पढ़े ही नहीं है, लग रहा है इसने पढ़ लिया है, बल्कि उसने किताब भी नहीं, पर वो आधे घंटे पहले आके सबको नर्वस. So this was that question which was a false question. Both the statements are wrong, but UPSC is placing it in a very formal manner. To tick D, you have to have guts and faith on yourself. To tick D, you have to, because by reading the question most likely you will think कि नहीं इतनी बड़ी बड़ी बातें गलत नहीं हो सकती. The such big things cannot. You need to have two things: guts to be sure about yourself that if I am answering, I am well read, I have answered. Otherwise, most likely इसको नहीं तो इसमें एक में आप फंसना ही फंसना है. ठीक है. सो जो हंसते खुशते जाएगा एग्जामिनेशन हॉल में उसी का सही होगा. होते हैं ना कुछ हंसे ही नहीं है 20-22 साल से. ओके. सो क्वेश्चन नंबर 6 ऑप्शन डी, neither 1 nor 2. ओके. We can take this, then we'll take a break. Which of the following in Indian polity is essential feature that indicates that it is a federal character? The independence of judiciary is safeguarded. The union legislature has elected representatives from constituent units. Union cabinet has elected representatives from regional. कुछ भी मतलब कुछ भी regional parties कहाँ से आ गया? Fundamental rights are enforceable. Fundamental right can be in a unitary country or can be in a federal. It has nothing to do with federalism. कहीं भी हो सकती है. Union legislature has elected representation from constituent unit. क्या this what you call in those countries which are unitary in nature, they can be. So the correct answer would be independence of judiciary. That is A. क्यों? Because जब भी federalism बनेगा, whenever a federal country is formed, there will be a dispute between center and state. So this will be decided by the what you call by the judiciary. How many we have left? Achha, ample of. So we'll discuss few more, then we'll take it. Okay. So with reference to anti-defection law, consider the following. The law, this is a factual question. In this you cannot make a mistake. First, anti-defection law में एक लिखा हुआ है, nominated member can join a political party within 6 months, but they cannot join after 6 months. It says the law specifies that a nominated member cannot join a political party within 6 months. Actually, he can. So if you will remove OT, Operation Theatre, अगर आप remove करेंगे या not remove करेंगे, so this statement will become a. So ये कह रहा है the law specifies that a nominated legislator can join a political party within 6 months, but cannot. So since they have added cannot, so it is a wrong statement. So the law does not provide any time frame. There is no time frame mentioned in the law. So it is an easy. We'll settle for 8 ka. B for Bombay. Okay, that is 2 only. Now, if an area is brought under 5th schedule, which of the following best reflects the consequent? It would create a local self-governing body in that area. Only a area under 5th schedule has local self-governing body, or Bihar doesn't have. Haryana, Rajasthan, Himachal Pradesh also have. So it has nothing to do with that. Only if it would have said that in a 5th schedule area, Panchayat Extension to Schedule Areas Act, it is an easy law. I have shown in the class also. Most of the provisions are there. अगर ये कहता कि उनको special power होगी, then it would have been a correct area. A local self-government can be in a 5th schedule also, can be in other areas. So this is a wrong statement. That that area will be converted into a union. So Delhi is a union territory because there is a 5th schedule. So कोई logic है ही नहीं. So the state having would be declared as a special category state. Acha, Gujarat has a scheduled area. Now Gujarat should be given a special category status. Then what will Bihar and Andhra Pradesh do? So Gujarat has a scheduled area. So is Gujarat a special category state? No. So this is a wrong statement. So ऐसे भी by eliminating these three, you will get the राइट, दे वुड ट्रांसफर, इसमें ओनली टू, ये दोनों मेसिव कंफ्यूजन है। एंड मोस्ट लाइकली इन द एग्जामिनेशन हॉल द इनर जील ऑफ यू बोलेगा इसको तुम करो टिक, ये सही है, एंड यू विल टिक बी, क्यों, यू थिंक ओके डिसेंट्रलाइजेशन लोकल सेल्फ, हाँ इसमें होगा, बट लोकल सेल्फ गवर्निंग बॉडी इज नॉट नेसेसरी इन अ व्हाट इज द डिफरेंस, जनरल डिफरेंस इज कि देयर आर जनरल लोकल सेल्फ बॉडीज, ठीक है, जो अलग अलग जगह है। फिर यू हैव फिफ्थ शेड्यूल वेयर दे हैव रिलेटिवली मोर पावरफुल देन द बाप ऑफ लोकल सेल्फ गवर्नमेंट, दैट इज द ऑटोनोमस डिस्ट्रिक्ट काउंसिल। सो अगर आप ऐसे फ्रेम पे रखेंगे, सो लोकल सेल्फ गवर्नमेंट हैविंग पावर्स इज नॉर्मल, then we have the special in fifth schedule, and then last level of decentralization is in sixth schedule। गौर से सुनिए, तीन तरीके के, ऐसे तो मैं और भी बता सकता हूं, मणिपुर हिल काउंसिल, ले हिल काउंसिल, कारगिल हिल काउंसिल, गोरखा टेरिटोरियल एडमिनिस्ट्रेशन, बहुत सारे हैं गैर से। लिसन, if when it comes to democratic decentralization, what is democratic decentralization? The art of decision making should be devolved at the grassroots level, decision make, for example the village should decide that what should be the pond, how the trees will be planted, all such thing, so decision making should be, क्या है democratic decentralization, यानी लोकतंत्र को ground level पे भेजिए। there is one more question which will, so the art of decision making should be devolved at the grassroots level, so it says that what you call local self governing body. Now for example article 243A of the constitution, that what will be the power of gram sabha will be decided by the respective legislature. So बिहार की पंचायत में ग्राम सभा का क्या पावर होगा, ये डिसाइड करेगी बिहार की legislative assembly. So in other parts of the country, 70-80% part of the country, you have other where state legislature will decide. Now in scheduled areas, the power of gram sabha is defined in the law, that is Panchayat Extension to Scheduled Areas Act 1996. So this is category 1 panchayats who have less power. Then you have category 2 panchayat, that is in scheduled areas, who have relatively more power. Then you have category 3, which is not, which is autonomous district council, which is the extreme level of decentralization. So panchayats in other areas will have less power, panchayats in scheduled areas will have relatively more power. Autonomous district council तो पंचायत से मुकाबला ही नहीं है, they are autonomous district councils, they have power on almost everything that you can imagine. So yani the most powerful body at the grassroots level in the entire constitution is autonomous district councils, which are 10 in number. Assam में 3, मेघालय में 3, मिजोरम में 3, and 1 in Tripura. So the answer here would be 9A. Okay. Which of the following are correct about the Constitution of India? Power of municipalities are given in Part 9A of the Constitution. Now this is something which is provision related to the Constitution. Now this was a question which was what do you think should be the answer? बताइए, ये क्वेश्चन पूछने का यूपीएससी का मकसद क्या है? What is the purpose of asking this question? Purpose of asking this question is that whether you have read from Lakshmikant or you have read the Constitution. I'll show you. Now, how many questions you saw till now where UPSC is asking from the Constitution? At least 1 or 2 questions every year. Why they are asking? They don't want you to read a secondary source, but read the primary. And this was the toughest of that. If we say the Constitution of India, we can, okay. Going by this, if you see the Constitution of India, okay. These are chapters, okay. These are chapters. Now it says here, now this question most likely you will commit a mistake because this was a factual question. These questions were too factual in nature. It says the municipalities are given in Part 9 A of the Constitution. This everyone knows that municipality is given in Part 9 A of the Constitution. Second is that emergency is given in Part 18 and provisions related to amendment is given in Part 20. Okay. So emergency is given in Part 18. Now you see here. It is not possible na humanly to remember all the parts. So if you see the 352 जाइए. So you see here 352, emergency is given in part 18. Getting my point? So part 18 is emergency. Now the next question they are asking is that what you call provisions related to amendment is given in part 20. So you see article 368 is given in part 20, but most likely you are going to commit a mistake, क्योंकि इतना एग्जाम हॉल में if you have not read it carefully, then you will make a mistake कि कौन सा किस part में. If we take the question, so they want you to read the constitution. Okay, so this all the three statements are correct, so we'll settle for option D, 1, 2 and 3. Now it says there is a parliamentary system of government because Lok Sabha is directly elected by the people. Not necessarily, can be any other presidential form. Parliament can amending the constitution has nothing to do with parliamentary form of government. Raj Sabha cannot be dissolved. Council of Ministers is collectively responsible to Lok Sabha, Article 75 clause 3. So this is a question 1D. This was an easy question. Okay. Democracy, now this again is an intel which UPSC has drafted, you will not find in the book. कह रहा है लोकतंत्र क्या है? Democracy superior virtue lies in the fact that it calls for band of dedicated party workers. Dedicated party workers होने से कोई democracy का लेना देना नहीं है. A superior individual with dynamism and vision. So superior individual, how can an individual be superior? You are saying a superior. Here the intelligence and character of ordinary men and women, क्योंकि democracy is people's rule, so it is ordinary men and women who take all the decisions. Before election, before independence, only few people were having the right to vote. Then we believed that a superior individual with dynamism and vision. So this was not in a democracy. So answer would be A for apple. Okay. Executive leadership, all these. Which of the following choose the one that brings out the principle underlying the cabinet form of arrangement? So an arrangement for minimizing the criticism. Is the cabinet there to minimize criticism? This is just an English statement which they have given a very long statement. Mechanism for speeding up the activities of government. A mechanism for parliamentary democracy for ensuring collective responsibility. A device for strengthening the hands of government whose hand over people is the state of decline. This and this is eliminated. This too is left. For speeding up the activities of government whose responsibilities are increasing day by day. So those countries which don't have cabinet form, do they not have speeded government? So all these are fallacious argument. Correct answer would be mechanism of parliamentary democracy for ensuring collective responsibility of the government to the people. This is what you call the main advantage of parliamentary form of government is कि head of the government cannot be challenged without election. Executive remains responsible to the legislature. You know that because article 164 you have the council of ministers shall be collectively responsible to state legislative assembly. Article 239 AA, the council of ministers shall be collectively responsible to UT assembly of Delhi. Article 75 clause 3, the council of ministers shall be collectively responsible to the house of people. So be it center, article 75, state, article 164, UT, article 239 AA, JK reorganization act, everywhere you will find the same thing. Council of ministers are collectively responsible to Lok Sabha or state legislative assembly. Okay, so we'll settle for executive responsible to the legislature. Okay, so this is something which is there. A constitutional government is one which is multi-party government, not necessary. Limited government, popular government, not necessary. Government by legislature, no. Answer would be limited government. So we can take a 5 minutes break, not very long. We come back and we'll continue from here. So, constitutional, see, constitution is the fundamental law of the land. If there is a, now listen to me carefully, constitution, I'll speak in Hindi then in English. Constitution के होने से क्या होता है कि constitution superior है, जुडिशरी एग्जीक्यूटिव लेजिस्लेचर सुपीरियर नहीं है, सबको उतनी ही पावर है जितना कॉन्स्टिट्यूशन ने दिया है. सो द पर्पस ऑफ द कॉन्स्टिट्यूशन इज टू लिमिट द गवर्नमेंट. इफ देर इज नो what you call constitution, they may behave in an arbitrary fashion. So it says a constitutional government is a government that is limited government. Now this is something, a parliamentary system we have already discussed. All political parties, government is responsible to the parliament, and the parliament can be removed by it. This is elected but can be removed, chosen by. So this is the correct answer. That is 6 ka B. Okay, this is easy. Same question which we discussed. Now, we adopted parliamentary democracy, but what is difference between India and British? As regards legislation, British parliament is sovereign, but in India, powers of parliament is, because British has an unwritten constitution, so parliament is sovereign. In India, parliament is not sovereign. In India, matters related to constitutionality of amendment are referred to the constitution bench by the, what should be the statement? Are all matters referred to the constitution bench? Not necessarily. So they have tried to confuse, so this will settle for 7A1 only. In India, matters related to constitutionality of amendment of an act of parliament are referred to the constitution bench. An act of parliament, not necessarily a constitution amendment. It can also be an ordinary law. Then not necessarily, it will always be decided by a constitution bench. So A is the correct answer, one only. Which one? This is a beaut. This is what asked on 10th October 2021. What is the definition of state? This is a very easy question, but many students got it wrong because of conceptual lacking. State matlab, it should have a fixed boundary. It should have a fixed population. Although people die and give birth, take birth, but there is a certain population that is always fixed boundary, sovereignty, fixed population, and it must be recognized by other government, and there should be a government there. Okay. So, for example, if other countries are not recognizing, so although there are multiple definitions, but Treaty of Westphalia prominently for one, it should have a fixed boundary, it should have a fixed population. That doesn't mean people will not die. People will immigrate E and immigrate I also, but there will be a fixed population. Then there will be a what you call sovereignty that is there, and that government should be recognized also, okay, by other. There should be a responsible sort of government. So it says a society permanently living in a definite territory. So this is the correct, yes. State means it should have a fixed boundary with a central authority and executive responsible to central authority and independent judiciary. Acha, North Korea is not a state. Saudi Arabia is not a state. So they don't have an independent judiciary. So this statement is a wrong statement. A number of persons who have been living in for a very long time with their own culture. Acha, they can be land of multiculturalism, India, Canada, Australia, and US. And South Sudan was carved out in 2012. So South Sudan will not be a state because it is not living for a very long time. So this is a wrong statement. कह रहा है should be living for a very, and I have told you कि जैसे ही UPSC superlative term use करे, मतलब statement यहाँ long नहीं, very long time. So this is also a incorrect. I told you na, most of the time when you will see a superlative term being used, it is a wrong, very long time. A politically organized people possessing an authority to govern and maintain and protect their natural right. Acha, those countries where dictatorship is there, they are also a state, but they don't have natural rights. Not necessarily, कहीं dictatorship भी हो सकती है, monarchy भी हो सकती है, semi-democratic, flawed democracy भी हो सकती है. So answer would be A community of person permanently occupying fixed population, definite territory, independent of external controls, तीनों कंडीशन लाइन से फुलफिल हो रहा है. फिक्स पॉपुलेशन, डेफिनिट टेरिटरी, सॉवरेनिटी एंड एन ऑर्गेनाइज्ड गवर्नमेंट. आंसर शुड बी 10 का A. These are looking very decorated, but this was an easy question if you read the question carefully. Here independent judiciary is an eliminating factor, here a very long time, here natural rights, so you will eliminate A is the answer. Which of the following fact in a liberal democracy? In a liberal democracy, there should not be centralization of powers. There's not, in a liberal democracy, you see which of the following constitute best safeguard. So if there is an elected government, okay, an elected government is arresting anyone whenever it feels like. So having an elected government does not mean that liberalism is being followed. हो सकता है government arbitrary हो, so you require an independent judiciary. पर यहाँ कह रहा है committed judiciary. Committed judiciary means judiciary is committed to the government. So that is exactly opposition of liberty. So answer would be separation of powers. When power is separated between judiciary, executive and legislature, then nobody will become too powerful and liberty will be safeguarded. If anybody is arrested, police job ends there. Now it is the judiciary which will decide that whether the person should be put in jail or not. So the separation of powers mein power is not being concentrated, which leads to liberty. Answer would be separation of power. These are easy questions. Committed judiciary means judiciary that is committed to government, which is wrong. Constitutional government means where a government is limited by the constitution. US is also a constitutional government where a head enjoys a nominal power. No, in America the head enjoys a there is presidential form of government. So a government whose head enjoys real powers, not necessary. In India, the head of the state does not enjoy real powers. Representative government with federal structure, not necessarily. There can be a written constitution and a unitary country, Japan. There can be a unitary country and a written constitution. Zaruri to nahi. There is so many countries which are not federal, so we'll settle for D, 10D. Which of the following reflect the chief purpose of the constitution? Objectives for making necessary laws, creating of political offices. US constitution is of 19 pages. So political offices are not always created by the constitution. It ensures social justice, equality, social justice, social equality, social security. Social security is given. Indirectly it is promoted, but not necessarily in every constitution. So the correct constitution ka matlab hai, Constitution is the fundamental law of the land. All laws are subservient to the constitution. It reflects the ideology and philosophy of the country. And most importantly, government should function within the mandate of the constitution. Yani constitution, Supreme Court se kaha basic structure. Supreme Court ne kaha first basic structure is supremacy of the constitution. जैसे ही सुपरमेसी ऑफ द कॉन्स्टिट्यूशन हुआ, सेक्युलरिज्म भी हो जाएगा, फेडरलिज्म भी हो जाएगा, लिबर्टी भी हो जाएगी, इक्वालिटी भी हो जाएगी, स्टेटस भी हो जाएगा, स्टेट भी हो जाएगा. एवरीथिंग विल फॉलो इफ देयर इज सुपरमेसी ऑफ द if any organ thinks that it is supreme, not the constitution, then that organ will defeat the purpose of supremacy of the constitution. Constitution का मतलब ही यही है. It gives powers to various organs and they function within the powers given. I can spell out 15 articles where you will see that they will function as per the power given by the constitution. So constitution का मतलब है government को limit करना. Fundamental rights में ये, most of the fundamental right don't say that you do this. Fundamental right में ये नहीं कह रहा है ये करो. No person shall be denied equality before law and equal protection of laws. Don't do this. The state shall not discriminate on the grounds of religion, race, caste, sex, place of birth. Article 15. ये नहीं कह रहा है you do. ये कह रहा है ये don't do. The state, there shall be equality in matters of public employment. Nobody shall be discriminated citizen on grounds of religion, race, caste, sex, place of birth. Untouchability is abolished and practice in any form is forbidden. The state shall not award any title. Yani pure fundamental right mein most of the time it is not saying to do something, it is asking not to do something, and I will not, we have no time at all. Otherwise I would have explained that fundamental rights were added in American Constitution. उनको उनका जन्म ही इसलिए हुआ था कि सरकार को लिमिट करना. So if I show in the class also, you'll download the American Constitution, go to First Amendment, it is written Congress shall make no laws. So it is rather than giving a right, it is putting a restriction on the Parliament. So fundamental right, for example, you are walking by the lanes of old Rajendra Nagar. Somebody arrests you unnecessarily. He cannot do that. No person shall be deprived of his property, life of personal liberty, except through a procedure established by law. So no person shall be deprived of his life or personal liberty except through a procedure established by law. So you cannot, your liberty cannot be taken away except through a law. So government is restricted by the it is not DPSP. DPSP it is not saying not to do something. It is saying to establish welfare state, minimize inequalities in income, establish village panchayat, provide legal aid, give them assistance in unemployment, old age, undeserved want or any right to work, any assistance in old age, any such thing, provide maternity relief, give them living wage, establish uniform civil code, take care of early childhood care, take care of weaker sections, provide public health. पूरे DPSP में कह रहा है you have to do something, and most of the time fundamental right says you have to not to do something. Article 21A में कह रहा है you have to do. The state shall provide free and compulsory education to all children in the age group 6 to 14 years in the manner statement determined by law. So some fundamental rights are also positive in nature, but most of them are negative, putting a restriction on the power of the state. So constitution, chief purpose है constitution का सरकार की हदों को limit करना, limit the powers of the government. If you see here, who is the custodian of the constitution? Custodian of the constitution is Supreme Court, because if your fundamental rights, Supreme Court said in one of the cases that constitution is supreme, but we will say what is constitution. Constitution is supreme, but we will say what is constitution because we are the final interpreter of the constitution. If constitution is being violated, you won't go to president, you will go to the supreme. Although Article 60 of the constitution, president takes an oath that I will preserve, protect and defend the constitution. But technically, if your fundamental rights are violated, you will go to the Supreme Court, you will not go to the president. So the custodian of the constitution would be Supreme Court of India. Gram Nyayalay's Act. So as per Gram Nyayalay's can hear civil and इसमें कुछ भी नहीं है. Gram Nyayalay's can hear criminal cases also and civil cases. Those cases which are mentioned in first schedule are criminal, second schedule are civil. So Gram Nyayalay's can take civil case also and criminal. This is fact, nothing to understand. So this is a wrong statement. Act allows the activist to act as mediator. Yes. The district judge shall appoint in consultation with the district magistrate, appoint the conciliators who are local people of integrity and the qualification will be decided by High Court. तो इस एक्ट में कुछ गांव के दो चार मतलब थोड़े सम्मानित आदमी, respectable people of the village are appointed as conciliators. They will try to arrive at a compromise between both the parties. The district judge shall appoint the conciliators in consultation with district magistrate as per the rules made by the High Court, so that there should be amicable settlement. So ये statement एक correct statement है. We will settle for B for Bombay. That is 2 only. What is judicial review? In judiciary to question the wisdom of laws? No. The job of judiciary is not to question the wisdom of laws. To review all laws before they are assented by the president. Not necessarily. Say 104th Constitutional Amendment Act was not challenged. There are so many laws which are not challenged. So not necessarily कि हर amendment को challenge किया. So power of judiciary to review its own judgment. Students are always confused. Article 137 of the Constitution. Article 137 says कि जो judgment court ने दे दिया है, a judgment which they have given, they can review it. But that doesn't mean judicial review. Judicial review means reviewing the constitution amendment, ordinary laws and the executive policies. Article 137 और Article 32, 13 और 131 में अंतर है. 32, 13 and 131 means you challenge the laws, you challenge the executive order. 137 तो मतलब you gave a judgment, now somebody, हुजूर एक बार फिर से देख लीजिए, see it again. So that is reviewing its own judgment. Sabrimala case, first zillions of examples are there. You file a review petition under Article 137 of the Constitution. Supreme Court can review a judgment which it has already given. It should not be, reviewing a judgment should not be confused with judicial review. A new law or a new executive action or constitution amendment is being reviewed, then it is judicial review. Already किसी judgment को review करना जो उन्होंने दे रखा है उसको कहते हैं reviewing its own judgment. UPSC want to trap you between Article 137 and 32. 32 means Parliament made a law that nobody will speak in the afternoon. You challenge that. That is judicial review. But a judgment that is given by Supreme Court, people will request, Hujur ek bar phir se ho jaye. Once you more listen. So that is reviewing its own judgment. That is Article 137 of the Constitution. So judicial review is different from reviewing its own judgment. So ये statement wrong है. कह रहा है review its own judgment. It is not judicial review. It is Article 137. Judiciary to pronounce upon the constitutionality of laws and executive order. A would be the answer. Okay. With reference to the Constitution of India, prohibition or limitations contained in ordinary laws cannot act as prohibitions on constitutional powers under 142. Okay, गौर से सुनिए. कई बार law is not enough to do justice. Law is not enough to do justice. For example, Supreme Court said कई बार, so many cases where law is not enough. The Honorable former Prime Minister Rajiv Gandhi ji, their killers were released by Supreme Court using Article 142. For example, the what you call in one of the dispute related to religious site, Supreme Court ordered the state government to give them also religious site somewhere else. Okay, so article कई बार law is not enough to do जस्टिस, तब कंप्लीट जस्टिस करने के लिए सुप्रीम कोर्ट को ब्रह्मास्त्र दिया गया है, दैट इज आर्टिकल 142. व्हेन द लॉ इज नॉट एनफ टू डू जस्टिस, देन टू डू जस्टिस सुप्रीम कोर्ट कैन डू एनीथिंग, दैट इज आर्टिकल 142. We don't have time, still I'll give you an example. For example, there is a site, two communities are fighting related to religious site, whether this religious site belongs to party A or party B. So Supreme Court ruled that no, this belongs to party A. So party B, Supreme Court said, should be given land somewhere else. So here Supreme Court said we are using powers under 142 because the dispute was whether it belongs to A or B. Supreme Court has given to A, but to compensate B, it said it should also be given land somewhere else, which was not the plea in the ये क्वेश्चन, ये केस का कोई मैटर था ही नहीं, पर सुप्रीम कोर्ट ने कहा कंप्लीट जस्टिस करने के लिए इनको भी कहीं लैंड दी जानी चाहिए. सो दैट इज कंप्लीट justice, that a land should be given to them, that is. So article 142, kai baar law is not enough to do justice, then to do complete justice court can do anything, that is article 142. अब इसको पढ़िए. The decision taken by election commission उड़ गया क्योंकि election commission has nothing to do with 142, it is article 324 of the constitution. Supreme Court of India is not constrained in exercise of powers by law made by parliament. So Supreme Court is not restricted by law, it can do anything to do complete justice. In eve of grave financial crisis, it has nothing to, financial crisis is financial emergency, article 360, it has nothing to do with this. State legislation, it has nothing to do with state. So answer would be B for बॉम्बे, कि कई बार लॉ एनफ नहीं है इंसाफ करने के लिए, तो कोर्ट कुछ एक्स्ट्रा पावर यूज करेगा ताकि इंसाफ हो जाए. सो सुप्रीम कोर्ट इज नॉट कॉन्स्ट्रेंड, लिमिटेड, रिस्ट्रिक्टेड, इनहिबिटेड, स्टिफल्ड, स्टॉप्ड, व्हाट यू कॉल कट शॉर्ट by law. Supreme Court can do anything to do complete justice. Supreme Court is not constrained in the exercise of powers by the parliament. Option should be B for Bombay. Now this is factual question, nothing. The motion to impeach a judge cannot be rejected by the speaker. In fact, this is a current affairs question. That year it was rejected by the chairman. So a motion to remove, although we will use the term impeachment only for president, for all constitution never uses the term impeachment for anybody other than president. For all others, they are removed, president is impeached, and there is a reason behind it, leave that. So the motion to impeach a judge cannot be rejected by speaker, can be rejected by the speaker. Few years back, opposition parties introduced a motion to remove Chief Justice of India, but that was rejected by the chairman. So this is a wrong statement. The Constitution of India defines incapacity. No, they are removed on the grounds of incapacity or proved misbehavior, which is not defined in the Constitution. Second statement is also wrong. The process of impeachment is given in Judges Inquiries Act. Yes. If the motion of impeachment is taken for voting, the law requires the motion to be backed by each House of Parliament, supported by a majority of total membership of that House, and by not less than 2/3 of the members present and voting. So this is also a correct statement. So we will go for 2, 3 and 4. So we'll go for C for Calcutta. That is 6, 5 ka C. Now again, this is a very easy question. 2020 में prelims में पूछा था. Who all are entitled to free legal aid? I have showed the law also in the class. सबसे पहले इसमें OBC eliminate कीजिए, क्योंकि वहां SC ST लिखा हुआ है. बस OBC eliminate कर दीजिए. आंसर क्या दिख रहा है? You will eliminate 3, तो ये उड़ गया और ये. Now it is 1 and 2 and 1 and 4. तो 1 तो 100% श्योर है, तो या तो 2 होगा या तो 4 होगा. So we'll see transgenders with an annual income of 2 lakh, all senior citizen. So you know that ki senior, all, for example, there is a billionaire senior citizen. There is a billionaire senior citizen भी अमीर होते हैं, है ना भाई? ऐसा तो नहीं कि सीनियर सिटीजन देखे तो आप एकदम सोचने लगे. गेटिंग माय पॉइंट? डेमोग्राफिक विंटर ऐसा नहीं. सो सीनियर सिटीजन कैन ऑल्सो बी अ बिलियनियर. व्हाई शुड ही बी गिवन फ्री लीगल एड? सो दिस इज 4 और 3 को मैंने एलिमिनेट कर दिया. अब कुछ करने की. आंसर ट्रांसजेंडर नोबडी नोज. दिस इज समथिंग विच इज स्टेट स्पेसिफिक. तो ये तो मतलब ये आपको नहीं मालूम होगा क्योंकि इट इज नीदर मेंशन इन लक्ष्मीकांत नॉर मेंशन इन योर बुक. पर ये आपको मालूम होगा कि ओबीसी नहीं है. तो पहले तो ओबीसी एलिमिनेट करेंगे 3 और 2, फिर सीनियर citizens we will eliminate. So we'll get an answer A, 1 and 2 only. This was a factual question. A retired judge of Supreme Court can be called back to act as Supreme Court judge with the prior permission of President. Yes. A High Court has the power to review its own judgment. One of the most controversial question. all the answer keys took this statement as correct. Supreme Court said no. So, UPSC said no. UPSC said reason to deta nahi hai, shraddh ke baad answer script they release the answer key after the shraddh. Okay, so they released the answer key after 1 year, and then in this they said कि High Court has the power to review its own judgment is a wrong statement. क्यों? क्योंकि आर्टिकल 137 says that Supreme Court has the power to review its own judgment. High Court का nowhere it is mentioned in the Constitution. Although scholars say कि भाई any court that has the power of judicial review can review its own judgment, as well as the High Court is most importantly Article 215. High Court is a court of record. Its judgments are in perpetual memory. Then it also can review its own जजमेंट. सो सारी आंसर की में दोनों स्टेटमेंट को करेक्ट माना गया था, पर यूपीएससी ने सिर्फ एक को करेक्ट माना. यूपीएससी ने कहा ऐसा कॉन्स्टिट्यूशन में तो लिखा हुआ नहीं, सिंस इट इज नॉट मेंशन्ड फॉर हाई कोर्ट, इट इज मेंशन्ड फॉर Supreme Court. So we will not take High Court on inference, we will take direct. So this statement is a wrong statement. High Court has the power to review its own judgment. Scholars believe that High Court has, but UPSC believes that High Court doesn't have, because there is no such article in the Constitution. Article 137 hai, but that is for Supreme Court, not for High Court. So we'll settle for A one only. Now अब ये easy question है, ये elimination के बिना ये question solve ही नहीं होगा. It says that the H.N. Sanyal committee recommended the contempt of court. Nobody knows. This statement is false. मतलब correct है, it's statement correct, but you don't have an idea that which committee recommended contempt of court. Constitution empowers the Supreme Court and High Court to punish for the contempt. Correct. Constitution defines civil and criminal. Whenever contempt is taught in any class of the country, among the first 3 lines that the faculty will say कि contempt has not been defined in the Constitution, it is defined in Contempt of Court Act. यहाँ लिख रहा है the Constitution of India defines civil and criminal contempt. यानी so I will eliminate 3. I will eliminate 3. So I am left with either 1 and 2 and or 4. 4 says in India Parliament is vested with the powers to make law on contempt. Parliament has made Contempt of Court Act 1971. सो हमें ये पता है कि 3 रॉन्ग है और 4 सही है. सो 3 रॉन्ग है तो ये उड़ गया, और 4 सही है तो देयर इज ओनली 1 ऑप्शन. सो दिस हैज टू बी डन बाय एलिमिनेशन मेथड, बिकॉज H.N. Sanyal it is you don't know, but UPSC is giving in both the statement it is H.N. Sanyal, मतलब 1 is also correct and 2 is also correct, पर 4 correct है. So which is the only option where 3 is not there and 4 is there? So B is the only option where 3 is not there and 4 is there. तो आपको अभी ये तो दिमाग इसी तभी तो फिर रील्स बनाने के लिए इतनी मेहनत तो करने, अब क्वालिफाई उसी लिए कर रहे हैं ना भाई, रील्स वील्स बनाएंगे. ओके, और क्या और किस लिए क्वालिफाई कर रहे हैं? इट बी वो तो इंटरव्यू विल से कि यार आई वांट टू सर्व द कंट्री and of course everyone must serve the country. It is upon every citizen to serve the country, not only civil servant, but they also know that they speak too much that since childhood I had a dream to make a change in the society. Then they will ask fundamental duties. Okay, so you'll not remember 8 ka B 1 2 and 4. Okay, so in India government law officers and legal firms are recognized as advocate, but corporate lawyers, acha, corporate lawyer is not an advocate, he is earning 1 lakh rupees an hour. So it says that corporate lawyers are excluded. So this is a wrong. भाई criminal lawyer भी है, आजकल तो corporate lawyers are earning. Okay, so this is wrong statement. Bar Council has the power to regulate the legal education. National Medical Commission for medical college, Bar Council for law college. 2 दिन पहले भी पढ़े, compulsory कर दिया attendance and all. UGC for universities, Telecom Regulatory Authority for telecommunication sector, Director General of Civil Aviation for civil aviation, Securities Exchange Board of India for stock market. You have what you call Insurance Regulatory Development Authority, IRDA for insurance. So every sector has a Dental Council of India for dental. So यानी कि हर सेक्टर की एक रेगुलेटरी बॉडी है, और लॉ कॉलेज की रेगुलेटरी बॉडी है बार काउंसिल. स्टेटमेंट इज करेक्ट, सो आई विल सेटल फॉर बी फॉर बॉम्बे. 9 क्वेश्चन नंबर 9, which of the is correct? So B2 only is correct. Okay, Which of the following does not lead to precedent rule? When there is a precedent rule, assembly is not dissolved. First it is suspended and then it may be dissolved. So उसको immediately dissolve नहीं करना है. Supreme Court SR Bomai case 11/5/1994 कि whenever a state is put under precedent rule, पहले आपको उसको suspend करना है. After that, get precedent rule approved by both the houses, then you can dissolve. You cannot dissolve the assembly directly. So ये statement is a incorrect statement. So we will eliminate one. Which of the following are अच्छा not पूछ रहा है, which are not necessarily the consequence. So dissolution of legislative assembly is not. So one is correct. Removal of council of minister necessarily है. So two is Ellie में. यानी पूछ रहा है कि प्रेसिडेंट रूल होने से क्या जरूरी नहीं है कि ये होगा. ठीक है, हो भी सकता है और नहीं भी. So with the in simple language, with the imposition of president rule, this will not happen necessarily. It may happen or may not happen. So it is compulsory that imposition of president rule there will be no dissolution. So dissolution of legislative assembly नहीं होगा. Supreme Court ने कहा है पहले it will be approved by parliament, then you can dissolve, not directly. So this is a correct statement. Removal of council of ministers, जैसे ही national emergency लगी, first is president rule लगा, first thing is council of ministers are dismissed. So council of minister is necessarily dismissed, but question is asking not necessarily. So two we will eliminate this. Oh, we'll get an answer that is B for स्टेट प्रेसिडेंट रूल का मतलब ही यही है कि काउंसिल ऑफ मिनिस्टर्स को डिसमिस करना, और कह रहा है कि जरूरी नहीं है डिसमिस होगा, तब तो प्रेसिडेंट रूल लगा ही नहीं. द वेरी फर्स्ट लाइन ऑफ प्रेसिडेंट रूल इज काउंसिल ऑफ मिनिस्टर्स इज dismissed. Council of Ministers is dismissed. So it says not necessarily. I will say Council of Ministers is necessarily dismissed. So we will eliminate 2 and we will get 1 and 3. That is B for Bombay. If a president exercises power under Article 356, then assembly of the state is automatically dissolved. No, not necessary. Power of legislature shall be exercised by parliament. Yes, correct. Article 19 has nothing to do with the president rule. This is article 358 of the constitution. Article 19 gets suspended if national emergency is imposed on ground of external aggression or war. ये national emergency की बात नहीं हो रही है, यहाँ बात हो रही है प्रेसिडेंट रूल. प्रेसिडेंट रूल से फंडामेंटल राइट पे कोई फर्क, there is no effect on fundamental rights in president rule. There is an effect on fundamental right under article 358 of the constitution. Article 19 gets automatically suspended if national emergency is imposed on grounds of external aggression and war. ये कह रहा है कि प्रेसिडेंट रूल लगने से आर्टिकल 19 सस्पेंड हो जाती है, बल्कि फंडामेंटल राइट्स को प्रेसिडेंट रूल से कोई लेना देना नहीं है. So there is nothing, fundamental rights have nothing to do with president rule. It is the national emergency which has to do with president rule. So they are confusing between national emergency and president rule. So this is wrong. President can make laws relating to that state. So this is, if then power of legislature shall be exercised by or under the authority of the parliament. B should be answer. President can make laws if the parliament allows the president, article 357 of the constitution. Both the statements are correct, but more correct would be option B for Bombay. Okay, so we will see 2 ka B. Now the executive power of the union is vested in the prime minister. Chintu question है. See the article 53. The executive power of the union shall be vested in the president. सीधा क्लियर कट लिखा है. आर्टिकल 53 ऑफ द कॉन्स्टिट्यूशन, द एग्जीक्यूटिव पावर ऑफ द यूनियन शैल बी वेस्टेड इन द प्रेसिडेंट एंड शैल बी एक्सरसाइज्ड ईदर डायरेक्टली और थ्रू ऑफिसर्स सबऑर्डिनेट टू हिम. सो यहां लिखा है एग्जीक्यूटिव पावर ऑफ द यूनियन इज वेस्टेड इन द प्राइम मिनिस्टर. तो ये एक गलत स्टेटमेंट है. प्राइम मिनिस्टर इज द एक्स ऑफिशियो चेयरमैन ऑफ सिविल सर्विसेज बोर्ड. कैबिनेट सेक्रेटरी इज द एक्स ऑफिशियो चेयरमैन ऑफ सिविल सर्विसेज बोर्ड. बोथ द स्टेटमेंट्स आर रॉन्ग. लगेगा, लगने लगा है पर लगेगा नहीं. Both the statements are wrong, so we will settle for 1D, neither 1 nor 2. Okay. Chief Secretary is appointed by the governor. This is not a constitutional appointment of State Election Commission or State Finance Commission that it will be done by the governor. Every action will be taken in the name of government, not necessarily by the governor. So statement is wrong. Chief Secretary has a fixed tenure. Supreme Court has recommended, but not necessarily. So again, both the statements are wrong, so we'll settle for 2D, neither 1 nor 2. Ab the value of each vote of each MLA varies from state to state. If you don't remember this, then it is your fault. Article 55 of the constitution, what is the value of vote of one MLA? total population of the state divided by number of MLAs into 1/1000. So every state value of vote of MLA depends upon the formula. So every state, it says the value of vote of each MLA varies from state to state. This is a correct statement. The value of vote of MPs of Lok Sabha is more than the value of, बिल्कुल नहीं, बिल्कुल 708 दोनों का है. So value, what is the value of vote of one MP? Value of votes of all MLAs of all states divided by number of elected MPs. So the value of vote of one MP of Lok Sabha is equal to that of Rajya Sabha. हाँ, overall the value of vote of Lok Sabha is more than Rajya Sabha, because Lok Sabha has 543 members and Rajya Sabha has 230. But every MP has an equal, I think 708 is there. So the point is कि so value of vote of one MP is same for Lok Sabha as well as Rajya Sabha. कह रहा है the value of vote of MPs of Lok Sabha is more than the value of vote of MPs of Rajya Sabha. No, this is a wrong statement. So we will A one only. No criminal proceeding shall. Acha, if anybody is having any other what you call option as an answer, I am giving answer which is correct and given by UPSC. It is choices yours, because OMR के बगल में they don't allow you to write कि नहीं इसमें तो ये बात है. They'll just ask you B and C. तो अब गलत कीजिए फिर. The person who attempts a wrong, he will bring 10 judgments of Supreme Court. यहाँ इस पैराग्राफ में तो कोर्ट ने ये कहा, पर यूपीएससी ने ऐसा कुछ फैसिलिटेशन काउंटर में ऐसा तो कुछ है नहीं कि आप जाके यू कैन गिव. सो डोंट ओवरथिंक, जस्ट व्हाट इज कन्वेंशनल यू फॉलो. ओके. No criminal proceeding shall be instituted against governor of a state in any court during his, yes, Article 361 of the Constitution. The allowances of governor shall not be diminished, yes. Okay, so all such protection is given. So you have 4C, both 1 and 2. In context of India, which is the most appropriate for bureaucracy? Technically, they should have used the term civil servant. Because cracy means rule, bureau means one who sits at the desk, or babu. So we live in democracy, we don't live in bureaucracy. UPSC ने अपने सिलेबस में टर्म यूज किया रोल ऑफ सिविल सर्वेंट्स, नॉट रोल ऑफ ब्यूरोक्रेट. क्यों? ब्यूरोक्रेट एक colonial term है कि those people, crazy means rule. Who is ruling? Bureaucracy is ruling. No, we are live in democracy and they are civil servants, they are not bureaucrats technically. हाँ, पब्लिक एडमिनिस्ट्रेशन में क्योंकि थ्योरीज बेस्ड है उस पे, then you say bureaucrat. But in the syllabus of UPSC they don't use the term, they use the term civil servant. So bureaucrat का क्या काम है? It an agency for widening the scope of parliamentary democracy. It means that there are no civil servants in presidential democracy. So not necessarily. हो सकता है हर जगह bureaucrat है. An agency for structuring federalism. Japan also has bureaucracy, but it doesn't have federalism. Agency for political stability. If अगर ऐसा होता तो 96, 98, 99, so many elections were conducted in short period. So not necessary that bureaucracy will provide political stability. If there is a coalition government, it can fall anytime. An agency for the implementation of public policy. उनका काम ही है public policy को implement करना. So we will settle for 5 का D for Delhi. You will use the term civil servant in mains. Okay. N. Gopal's Swami Iyengar committee, tough question. Okay. So you will make this mistake. Though better if you see some committee which you have not heard, then you will don't go for akkad bakkad. Most likely it will be wrong. So committee suggested that a minister and secretary be designated for pursuing administrative reform. No, this was suggested by first administrative reform commission. So this is wrong. Department of Personnel was constituted on the recommendation of administrative reform commission and was placed under what you call this. This is a correct statement. So we'll settle for B. Okay, 2 only. This was a tough one. Constitution of India classifies ministers into 4 rank. There is no such classification given in the, because this I shout in every time कि constitution में ऐसा कोई classification नहीं दिया हुआ है. So this is wrong. Article 75 of the constitution, there is no such classification. Total number of ministers in the government including shall not exceed 15% of this is 91st Constitutional Amendment Act 2003. किसी भी स्टेट में या सेंटर में 15% से ज्यादा मिनिस्टर नहीं होंगे, except some exceptions are there. साडी दिल्ली, here it is 10% for union territory. Okay, so for example, how many people can be made minister by Modi ji's government? 15% of Lok Sabha. So 15 5s are 75, 543 है ना, 15 5s are 75, 75 1540 हुआ, 15 4s are 60. So you have 6, 75 plus 6 is 81. 3 का 15% कैसे होगा? 3 का 10% is 0.3, 15% इज 0.45, 0.45 को आप मिनिस्टर, एक आधे को थोड़ी मिनिस्टर बनाएंगे. सो हाउ मेनी पीपल कैन बिकम मिनिस्टर? 15% of 543. What is 15% of 540? That is 81. 3 का 15% हो नहीं सकता है, 0.45 होगा. तो 0.545%, आधे इंसान को कैसे मिले? इधर साइड इज नॉट मिनिस्टर, इधर साइड ऐसा तो नहीं है. तो 81 पीपल कैन बिकम मिनिस्टर. व्हाट जो भी लोकसभा का स्ट्रेंथ है उसका 15% लोग मिनिस्टर बन सकते हैं. 15% ऑफ द स्ट्रेंथ ऑफ लोकसभा. हाँ, मिनिस्टर्स कैन बी फ्रॉम राज्यसभा और मिनिस्टर्स कैन बी फ्रॉम Lok Sabha, but the strength of Council of Ministers will be determined by Lok Sabha. So Lok Sabha has 543 members. How many people can become minister? 15 fours you have 15 fives 75. Then you have 43. 40 का 15% is 66. So 81 and 3 का तो 15% क्या है? UP में 403. So 15 fours 60. So how many people can become minister in UP? 60. Only 60. 91st Constitutional Amendment Act 2003. So answer would be B for Bombay, 2 only. Attorney General of India and Solicitor General are allowed to participate. Article 88 of the Constitution. Only Attorney General, not Solicitor General. तो ये point तो पहले wrong statement है, ये basic fact है. According to Constitution, Attorney General submits his resignation when the government resigns. All these things are not mentioned in the Constitution. Article 76 is about Attorney General. Article 88 is about, nowhere it is written that he will resign when there is a fall of government. So both the statements are wrong. We will settle for D, neither one nor two. Now you have to be having guts and confidence on yourself to go for D. Otherwise most likely you will think कि एक तो सही होगा ही और फिर next year. Okay, so it is very painful. They should conduct 2 times in a year. Okay, 8 का D. And then you will say थोड़े से. Everyone will say 3-4 question. That थोड़ा सा के लिए you require multiple times more clarity. Most of the students who are sincere are missing only by थोड़ा सा. Very few students you will find that how much marks you are getting 2. ऐसा कोई नहीं. They get marks but थोड़ा सा से you have to work hard. Okay. If the election of president is declared void by Supreme Court, all acts done by him becomes invalid. This is written in the Constitution. For example, the president takes oath on 25th July. So president every 5 years on 25th July. So 25th July, president took oath. After 4 months, the election was declared void. That doesn't mean that all things which president has done in 4 months, they will be valid. Otherwise, somebody will challenge now that presidential election has been set aside, then all the laws that he approved during that period also becomes invalid. So it is written in the Constitution that if the presidential election is squashed, then also whatever he has or she has done until that day, that will remain valid. यहाँ कह रहा है that will remain invalid. So exactly उल्टा कह रहा है. We'll delete this. Election for the post of president can be postponed on the ground that assemblies have been dissolved. लिखा हुआ है. Vacancy in electoral college shall not be a ground to challenge the election of president. So vacancy ये भी गलत statement है. When a bill is present to president, Constitution prescribes the time limit within which he has to decide. There is no Article 111 of the Constitution, assent of bills, no time is mentioned. So all the 3 statements are wrong. America में 10 days, India में no time, pocket veto. So all the 3 are wrong. We will settle for none. अब इसमें none टिक करने के लिए you need to have a lot of guts, क्योंकि अंदर से Mephistopheles Lucifer will say कि एक तो सही होगा ही होगा. तो you have to, how you will get this confidence? By working hard, which the parents say every day. I said okay. So I don't say work hard and all, because every day my parents call work hard, get up early in the morning, be honest, take bath, be clean. Getting my point? Study and take care of yourself. All these things every day they say. So I don't like saying those things. But you know, if you don't want to work, then also it's okay. So the point is कि 9 का D. Now this was the toughest question of 2023. This question was meant to be skipped. Okay, this will take half an hour explanation. This is see this question you will answer one if you have mugged the fact like anything, or you are very, very smart. So it says the nominated members are also eligible to be included in electoral college. ये article 54 of the constitution, nominated members don't vote in the election of president. तो ये तो चलो सबको मालूम है कि गलत है. Okay. the higher the number of seats, higher is the value of each MLA. Value of fraction depends upon population divided by number of MLAs. So if denominator is more, then numerator will be high or less. 2 divided by 100 is a bigger number, or 100 divided by 2? 100 divided by 2 is a bigger. So if 2 divided by 100 matlab denominator is a big number. So if denominator is big, then fraction will be big or less? Less. So denominator and fraction are inversely proportional, not directly proportional. So 1 MLA, value of vote of 1 MLA is equal to total population by number of MLAs into 1 by 1000. So it says that if there are more MLAs, the fraction will be high. No, because the more MLAs, the fraction will be low. क्योंकि वो कह रहा है number of population by number of MLAs. So denominator अगर ज़्यादा होगा तो value of fraction will go down. It says if there are more MLAs, the value of fraction is high. So this is also a wrong. These two statements you will answer. This was a bomb. The value of MLA of each MLA of Madhya Pradesh is greater than that of Kerala. ये तो भाई बेटर है कि आप इसको जाने दे. ये अभी there are 230 MLAs in Madhya Pradesh and there are 140 in Kerala. So you know this. Okay. मतलब you have an idea that Madhya Pradesh has more MLAs than Kerala. So denominator of Madhya Pradesh is 240 and denominator of Kerala is denominator of Madhya Pradesh is 230 and denominator of Kerala is 130. So 140. So Kerala में 140 denominator है, मध्य प्रदेश में 230 denominator है. So fraction किसका बड़ा होगा? केरला का. क्योंकि if the fraction is less, if the denominator is less, then fraction is high. If the denominator is more, then the fraction is less. You are getting my point. So कह रहा है value of vote of each MLA of Madhya Pradesh is greater than that of Kerala, which is wrong. Because MLA denominator of Madhya Pradesh is 230. So the value of fraction will be less. Denominator of Kerala is 140. Then the value of fraction would be high. So this is a wrong statement. ये common sense अगर आपको एग्जाम में क्लिक कर गया वहां, then you will correct. Otherwise, if you will start thinking कितना था फिर नहीं हो पाएगा. Because then you have to remember 28 states, Delhi and Puducherry. Now this was an easy question if you have been attentive in the class. Because I always say that out of 60 seats in Arunachal Pradesh, 59 is reserved for scheduled tribe, Article 332, and Puducherry you have 30 MLAs and 3 nominated. So the value of each MLA of Puducherry is higher than that of Arunachal Pradesh. So Arunachal Pradesh का denominator 60 है, अब Puducherry का denominator 30 है. So fraction किसका बड़ा होगा? The denominator of Arunachal Pradesh is 60 and the denominator of Puducherry is 30. So fraction किसका बड़ा होगा? Puducherry. So value of MLA of Puducherry will be higher than that of Arunachal Pradesh. Although numerator is also counted, but I don't want to make it confusing at this time when your brain is partially working. Okay, by after 3 hours, otherwise I would have explained about with taking population also. But common sense be if you would apply that the denominator of Arunachal Pradesh is 60 and the denominator of Puducherry is 30. So then of course the value of fraction of Puducherry will be higher than that of, so it says the value of vote of each MLA of Puducherry is higher than that of Arunachal Pradesh because the ratio of total population to the number of seats in Puducherry is greater compared to, which is a correct statement. So we'll settle for 10 ka only one. It says the legislative can be larger in size than, this is factual. Legislative assembly cannot be more than 1/3 of the legislative. Legislative council cannot be more than 1/3 of the legislative assembly. It says legislative council can be larger than legislative assembly. No. In fact, the maximum strength of legislative council will be 1/3 of the strength of legislative assembly. So ज़्यादा होने का तो सवाल, there is no question of more. This is a wrong statement. Governor nominates the chairman of legislative council. Election is conducted. There is no nomination. So both the statements are wrong. We'll settle for D for Delhi. The speaker of assembly vacates if he ceases to be a member. This is a basic fact that whenever the speaker is no longer a member of Lok Sabha, he will not be speaker anymore. He's removed as speaker. Only when there is a dissolution of Lok Sabha, then he can continue till the next Lok Sabha comes. Otherwise, if there is a Lok Sabha already in life and speaker gets convicted and he is disqualified. So if he is no more a member of Lok Sabha, then he will no more be a speaker. So the speaker of legislative assembly, if he ceases to be a member, this is a correct statement. When legislative assembly is dissolved, speaker shall vacate office immediately. No, whenever legislative assembly is dissolved, one office only continues, that is the office of speaker, till the first sitting of next Lok Sabha or assembly they will continue. It is a joint between two Lok Sabha. So this statement is a wrong statement and this statement is a correct statement. So we'll settle for 2A1 only. Okay, I know we are the governor, you know, this is the constitution that every year the governor customary address to the members of the house at the commencement of every year. When a state legislature does not have a rule on a particular matter, it follows the rule of Lok Sabha. Absolutely correct. So this ये इसमें कुछ नहीं समझना है. You know Article 87 of the Constitution, President addresses every year. So both are fact. So we'll settle for C for Calcutta. Okay, both 1 and 2. Here you see what is the main object of Panchayati Raj system? Financial mobilization? No. मतलब ये तो एक generic term है. People's participation in development, political accountability and democratic decentralization. So if you see the fundamental, what is the most important object? Democratic decentralization. So 3 to ho gayi. So we will first eliminate B. Then it says political accountability. Political accountability ऐसा ही एक generic term दे दिया है, ऐसा कुछ है नहीं. So we will eliminate 2. 2 is eliminated. So we'll get 1 and 3. People's participation in development and democratic decentralization. One can see. A minimum age for panchayat is not 25 years, but we know that minimum age for panchayat is 21 years, but only to become member. अब ये भी इसके पीछे भी लंबी कहानी है. Just remember, Constitution only says that the minimum age for panchayat will be 21 for a member. Chairman के लिए state legislature can make any age. UP has made 30. UP Municipality Act 1916 Section 43. So the point is, chairman के लिए age बढ़ा सकती है legislature, पर member के लिए age will be 21. It says a minimum age for person to become member is 25, which is wrong. It should be 21. Panchayat, if a panchayat is dissolved, the new panchayat will only be for the remainder period. This is a correct statement. So we will see 2 ka B for Bombay, 2 only. Now local self-government has nothing, it is not example of federalism, it is not example of administrative delegation, it is democratic you will not confuse it with direct democracy. Direct democracy तो initiative, plebiscite, recall और referendum है. ये डायरेक्ट डेमोक्रेसी नहीं है. इट इज अगर पंचायत में द वर्क इज डन बाय मुखिया एंड प्रधान इन यूपी, सो बाय हिम. सो इन पंचायत आल्सो, ऑल्दो ग्राम सभा आर्टिकल 243A promises direct democracy, but main power is democratic decentralization. So we'll settle for 3B. Okay, it says with reference to scheduled areas, consider the following statement. Within a state, the scheduled area takes place through an order of the president. This is a correct statement. The largest block administrative unit of the scheduled area shall be the district and lowest is village. This UPSC took as a correct statement. Okay. Chief ministers submit annual report. No, chief ministers don't submit. Governors submit annual report. So these 2 statements are correct. We will settle for B for Bombay, only 2. Now if you see here, the parliament, if the parliament wants to make a law on state list in national, if a resolution is passed by Raj, Article 249 of the Constitution, Parliament, if the Parliament wants to make a law on state list, there are only 5 situations on earth. Under these 5 situations, Parliament can also make a law on state list. When Raj Sabha passes a resolution by special majority, when there is a national emergency, when there is a precedent rule, when 2 or more states request the parliament to make a law for themselves, and Article 253 to implement an international treaty or agreement. So सिर्फ 5 ऐसा सिचुएशन है जहां पार्लियामेंट स्टेट लॉ पे, स्टेट लिस्ट पे भी लॉ बना सकती है. इफ देयर इज अ नेशनल इमरजेंसी, इफ देयर इज अ प्रेसिडेंट रूल, इफ 2 or more states request by themselves, if Raj Sabha passes a resolution empowering the parliament to do so, Article 249, or if to implement an international treaty or agreement, Article 253 of the Constitution. So parliament can make a law on state list if Raj Sabha passes by a majority of 2/3. So correct answer would be D for Delhi. Again, factual question, nothing to memorize. Yeah, to understand. Mostly here it is a factual thing. You have to ratify. So this is which of the following committees or commission recommended that governor should not be from the state? This is again a direct question from Lakshmi. It was Sarkaria Commission in 1983 to January 1988. उन्होंने कहा किसी भी राज्य का गवर्नर उस राज्य का आदमी नहीं होना चाहिए, तभी वो impartial होगा. A governor should be from some other state. So always the governor is from some other state, so that he will not be involved in local politics, and this was recommended by Sarkaria Commission. ऐसे भी you can find first reforms commission was not directly involved in federalism. National Commission to review the working of constitution was not involved in federalism. अब दो बचा, राजमन्नार and Sarkaria. Correct answer would be Sarkaria Commission. उन्होंने कहा गवर्नर दूसरे राज्य का होना चाहिए. Although it is not written in the article 152 related to the governor, but this is a provision that is there. Okay. Which of the following statement is correct as per the Constitution of India? Corporation tax is a state subject. The whole world knows that corporation companies pay tax to the union government, not to the state government. This is an entry in the union list. Interstate trade and commerce is a state subject. अगर दो राज्यों में trade state के पास होगा तो one राज्य will become more powerful. So interstate trade and commerce is not with the state but with the center. Interstate migration is subject under state list. Wrong. कुछ भी interstate होगा that will be to the center. तभी तो दो state होंगे. So answer would be interstate quarantine is a union subject under the union list. C for Calcutta. यहाँ कुछ नहीं करना था. Two things you should know. Interstate आया तो union आ जाएगा. And corporation tax is with the center. This everyone knows कि companies pay tax to the union, not to the state. So the only option left is C for Calcutta. Even if you don't know, very likely that you don't know that interstate quarantine is a subject in state, but you know these three, so you will eliminate and arrive at a. So कई बार direct question नहीं आता. By elimination you can arrive at an answer. So you have to work so hard. Sorry, मतलब समझ ही रहे. वो मैं नहीं बोलना चाहता because now you'll go home, somebody will call and say work hard. So this is the Northeastern Council was made and 2002 में amendment हुआ. So who is comprises of Home Minister? No. In Northeastern Council it is governors. In Zonal Council it is Home Minister. So we'll eliminate 4. So we get 1, 2 and 3. Zonal councils में there are 5 zonal council, north, east, west, south, center. All 5 zonal council Home Minister is the chairman. Chief ministers in the zone are vice chairman by rotation for 1 year. There is a standing committee also comprising of chief secretaries, but this is all about zonal council, not about north eastern council. So answer would be A for apple, 1, 2 and 3. Okay. With reference to the Constitution of India, no high court shall have jurisdiction to declare any central law to be constitutionally invalid. Article 226A. Article 226A said that no high court can declare a law as unconstitutional, cannot review a parliamentary law. That article has been deleted. So high court can also declare a parliamentary law as unconstitutional. There is a long constitutional reason behind it. Just remember this fact. So no high courts will declare a central law to be invalid. Yes, high court can declare a central law as invalid. This is a wrong statement. एक limitation था article 226A पर अब उसको delete कर दिया गया. So there is no such restriction. An amendment to the constitution cannot be called into question in Supreme Court. Then why 99th Constitutional Amendment Act was declared unconstitutional on 16th October 2015 in Supreme Court Advocates on Record Association case. So constitutional amendment can definitely be called into question in Supreme Court. So ये दोनों statement एक wrong है. Guts होगा तो you will go for D. That is neither 1 nor 2. Okay. 44th Amendment to the Constitution introduced an article placing the election of Prime Minister beyond judicial review. You know that 44th Amendment was made after emergency. So 44th Amendment will do everything to add judicial review, not to execute. Whatever excesses were done in emergency, they were removed by 44. So 44th Amendment का purpose था judicial review को लाना, ना कि खत्म करना. So common sense से भी you will see this as a wrong. Literally I have not read. I can say by common sense कि article 329A add हुआ था, but not by 44th amendment, that I know. But this, even if I didn't know the fact, I will know that 44th amendment was passed in 78 when a new government came to power and they were promoting judicial review. They were not restricting. So it is wrong statement. Supreme Court of India struck down 99th amendment as violation of independence of judiciary. This is a correct statement. We'll settle for B2 only. in which this in India this question has been dropped by UPSC. This question of 2023 has been dropped by UPSC because two answers are correct, first also and 42nd also correct. Although in जब नेहरू जी ने first constitutional amendment bill introduce किया parliament में, you can download first there is an app first constitutional bill में, he said I am going these constitution amendment is required to undo the some Supreme Court judgments. Question पूछ रहा है which of the following constitution amendment was believed to be enacted to overcome judicial interpretation of fundamental right? Answer would be first constitution amendment and also 42nd constitutional amendment with respect to article 31C and all. ठीक है, so parliament added something, so answer दोनों होगा, first भी होगा और 42nd. दोनों अमेंडमेंट सुप्रीम कोर्ट के जजमेंट को ओवरटर्न कर रहे थे. बोथ द अमेंडमेंट्स वर ओवरटर्निंग द जजमेंट ऑफ सुप्रीम कोर्ट. ऑल्दो इफ यू विल डाउनलोड द ऑब्जेक्टिव्स एंड रीजन ऑफ फर्स्ट कॉन्स्टिट्यूशनल अमेंडमेंट, इट इज रिटन देयर. Nehru ji said in the parliament that this is, if time would have been there, I would have read out, this amendment is also to overcome the judgment of judicial pronouncement. Since both the options were correct, so UPSC ने क्या किया, इस क्वेश्चन को ड्रॉप कर दिया. ओके. 71st Amendment Act added 8th schedule to the Constitution. See, Mathli was added by 91st later. So first we will eliminate Mathli. Okay, so you should know that Mathli was added later. So I am eliminating Mathli. So Mathli was added somewhere around 2002 or 3. So this we will eliminate. To what we will get. ऐसे भी आपको समझ होनी चाहिए कि Mathli was added around 2000 and 86th Amendment is 2002. So then 71st must be before that. So we will eliminate Mathli and we will get an answer that is 1, 2 and 3. Option A. As per Article 368, Parliament may amend, Parliament may add something, change something or repeal. So all the three statements are correct. We'll settle for 1, 2 and 3. कम से कम 5 क्वेश्चन आया है where UPSC is expecting you to read the original कॉन्स्टिट्यूशंस. कितने सारे, मैं क्लास में इसीलिए आई शो द कॉन्स्टिट्यूशन. अभी हमने कितने क्वेश्चन देखे वेयर दे आर आस्किंग फ्रॉम द, इफ यू विल नॉट सी द कॉन्स्टिट्यूशन, दे नो दैट यू आर रीडिंग फ्रॉम लक्ष्मी कांत और एनी, सो यू हैव टू गो टू द प्राइमरी सोर्स. बाकी चॉइस इज योर्स. So consider the following statement. Nari Shakti Vandan Adhiniyam, you know, that is 106 Constitutional Amendment Act. Provision will come into effect from 18th Lok Sabha. 18th Lok Sabha आ गई, 1/3 women है? No. So first तो we will eliminate. Okay. हाँ, so what we will get? भाई 18th लोक सभा आ गई, क्या 18th लोक सभा में 1/3 रिजर्वेशन है विमेन का? नहीं है. So first statement is a wrong. It says the provision will come into effect from 18th Lok Sabha. कहाँ? So next census के बाद, so we will eliminate 1. So we are getting an answer B, 2 and 3. So it will come into force 15 years after, it will be in force for 15 years. There are provisions for within the quota. Both the statements are correct. So हमें ये मालूम है कि we know that the present 18th Lok Sabha which has been constituted, there is no reservation for women in this Lok Sabha. It says this will come into force from 18th Lok Sabha. So first statement is a wrong, 100% wrong statement. So you first को eliminate करके you will get an answer that is 2 and 3, even if you don't know other two things. 6C. It was an easy question. What was the exact status of India on 26 January 1950? A very debatable question, but UPSC has given an answer की democratic, ये sovereign democratic republic. क्योंकि socialist and secular were added by 42nd Constitutional Amendment Act 1976 and came into force on 3rd January 1977. Although some scholars say कि India was secular even on 26 January 1950, but UPSC has gone by the preamble. So answer would be B for Bombay. Now you have the Constitution Day is celebrated on 26 November to promote constitutional values. Absolutely correct. On this day, Constituent Drafting Committee was set up. This was the day when Constitution was completed. So Drafting Committee will be set up on the day when, so common sense है, जिस दिन Constitution खत्म हुआ उस दिन Drafting Committee बनेगी या शुरू में बनेगी? So Drafting Committee will be constituted at the beginning, not at the end. So this is common sensical है कि second statement is a wrong statement. So we'll say statement 1 is correct but 2 is incorrect. 2 का सही. This was a factual question. This was an interdisciplinary question. If you have read this carefully, post Quit India movement, modern history, then you will answer, else you are going to make mistake. That who was the provincial president of Constituent Assembly before Dr. Rajendra Prasad? Patna se the Dr. Sachidanand Sinha ji. Okay, so answer would be D. Now, the Election Commission of India is a 5-member body. No, Election Commission of India is a 3-member body. So we'll eliminate 1. Okay, 2 is there, 3. Union Home Ministry decides the election schedule. No, it is not the Union Home Ministry but the Election Commission of India. Up see, now we have Election Commission. So Election Symbols Order 1968, all disputes arising out of election shall be decided by the Election Commission. And Samajwadi Party, Lok Janshakti Party, Shiv Sena, Nationalist Congress Party, 4 examples are there where dispute related to symbol has been decided by Election Commission. So I'll settle for D3 only. Now this is, which of the following is a constitutional body? अब ये कोई question है. National Human Rights Commission is a statutory body under Protection of Human Rights Act 1993. National Law Commission is neither statutory nor a constitutional body, merely an executive body. National Consumer Dispute Redressal Commission, no, it is a statutory body. So bacha National Commission for Backward Classes, Article 338, Clause B, inserted by 102nd Constitutional Amendment Act 2018. So Article 338B, so I will settle for A, only 1. Factual question tha. There is only 1 citizenship and 1 domicile. Yes. You cannot make your OBC certificate from 2 states. So you'll make only from 1 state. So there is 1 citizenship, 1. A citizen by birth can become head of the state. No. There is no such thing written for the president related to the qualification. So America mein you can become president only if you are a citizen by birth, not in India. So this statement is a wrong statement. A foreigner once granted citizenship cannot be declared. अब यहाँ extreme statement आ गया. Under any circumstances. कोई भी चीज अंडर एनी सर्कमस्टांसेस हो सकती है. ऑक्सीजन होगा भी कि नहीं अंडर एनी सर्कमस्टांसेस, दिस इज ऑल्सो नॉट श्योर. सो हाउ कैन यू से अंडर एनी सर्कम. सो ये एक ब्रूटली एक्सट्रीम स्टेटमेंट है जो मोस्ट ऑफ द टाइम दिस इज अ नो. कह रहा है कि इफ अ फॉरेनर इज गिवन सिटीजनशिप इट कैन नॉट बी टेकन अंडर एनी सर्कमस्टांस. ऑफ कोर्स इट कैन बी टेकन इफ सिटीजनशिप इज गॉट acquired by fraud, then that citizenship will be cancelled. So 3 is a wrong statement, so I'm eliminating, and 2 is also a wrong statement, so option would be. अमेरिका में आप प्रेसिडेंट तभी बन सकते हैं जब वहां citizen by birth है. If you are a citizen by birth, then you can become the president of America. In India, you can be citizen by birth, registration, incorporation, naturalization or descent. So किसी भी तरीके से अगर आप citizen हैं तो आप president बन सकते हैं. अमेरिका में only by birth. So this is the correct statement. 1A, 1 only. Now we have, for election to Lok Sabha, a nomination paper can be filed by any citizen of India whose name appears in the voter list. So this is residence. So Lok Sabha, Modi ji is from Vadodara. His name is in voter list in Ahmedabad. He stays in New Delhi but is an MP from Varanasi. So not necessarily that you have to be a voter of the same constituency. India is one, you can contest from any place. So anyone residing in India, impossible. Then the foreigner will also become a member of parliament. Any citizen of India, nahi. If he is disqualified under RPA 1951, then he cannot become an MP. Getting my point? Any residents from which constituent? नहीं, जरूरी नहीं है कि आप वहां के बाशिंदे हो, वहां रहने वाले हो. Not necessarily that you will be a resident. So the answer would be any citizen of India whose name appears in electoral rolls of a constituency. Easy है, citizen of India नहीं क्योंकि disqualification होता है, तो सारे citizen नहीं. Residing in India, तो foreigners are also residing in India. Resident of any of the same constituency, no. To contest Lok Sabha election, you can be resident of any. So we will settle for C for Calcutta. In the election to Lok Sabha, the winning candidate must get at least 50% vote. This is not, you have to get the maximum votes, not 50% vote. According to the constitution, the speaker's post goes to the majority party. There is no such thing mentioned in the constitution. A speaker post will go as per the election. So we will settle for D, neither 1 nor 2. Okay. According to the Constitution of India, a person who is eligible to vote can be made minister in a state even if he is not a legislature of that state. Yes. When Mamta Banerjee ji was appointed as chief minister, then she was not a member of state legislative assembly. She became a member from Bhawanipur within 6 months. So if a person is eligible to vote, can be made a minister for 6 months even if she is not a member of state legislature. Correct. According to RPA, a person convicted of criminal offense and sent to imprisonment for 5 years is permanently disqualified. Sabse pehle, not permanently disqualified, disqualified for 6 years, and not 5 years, it is 2 years. So second statement is wrong, first is correct. I will settle for 3A1 only. We have few only, don't worry. Now these are the most important part of the discussion. Yahan abhi tak jitne question the, that most likely you will make less mistakes. This part you will make more mistakes. और इसमें irony ये है कि इसमें ज़्यादा fact concept की ज़रूरत नहीं है. The irony is that it has less concept. It has everything to do with fact. So if you are prepared with the fact, you will get it correct, else you will not get it correct. Okay.
Completing the syllabus without proper knowledge of current affairs will not take you far in the UPSC Civil Services examination. Regulate and transform your preparation with complete coverage of news of relevance. Get a concrete hold of current affairs for UPSC CSE with Vision IS Monthly Current Affairs Revision Program starting from 20th September at 5 p.m. The program is your guide to get comprehensive news on one platform sourced through relevant resources such as The Hindu, Indian Express, Economic Times, PIB, Yojana and others. Enroll for complete coverage of current affairs including Indian polity and constitution, economy, international relations and more. Comprehensive assessment of preparation through MCQs and mains-oriented questions. Expert support through personalized mentoring and online doubt resolution.
So this is regarding Atal Pension Yojana. This is more of a factual question. Okay. More of a factual question. Here, honestly speaking, no concept but brute application of fact. So if you have memorized those facts, you will be able to get it clear. Else, nobody, even if a person knows the entire constitution or a true scholar of the law cannot answer if he is not aware with the facts. So schemes are some play. What is the implementary value of these schemes, which UPSC is asking, like, do you think Right to Free and Compulsory Education Act is able to incentivize school education in India? Critically evaluate the Right of Person with Disabilities Act. So these things are intellectual in nature. But when they ask schemes, you have to be thorough with the schemes, especially those which are important. Otherwise, it may lead to mistakes. And this is one area where majority of the students commit mistake because of not aware of the schemes. And it requires a bit of hard work because this is more about facts. Okay. So regarding Atal Pension Yojana, which of the following statement is correct? It is a minimum guaranteed pension mainly targeting unorganized workers. Okay. Only one member of a family can join the scheme. There is no such thing. So first we'll eliminate two. Same amount of pension is guaranteed for the spouse after the subscriber's death. So this will be C1 and 3 only. So if you go through the very what you call aspect of this thing, that in this only one member of the family can join the scheme, there is no such thing. Okay. So minimum guaranteed pension and spouse also gets the same. So 1 and 3 will settle for C1 and 3. Now regarding DigiLocker, sometimes seen in news, which of the following statement is correct? It is DigiLocker system offered by government under Digital India program. Absolutely correct. Allows you to access your e-documents irrespective of your physical location. I also use the same. So this is also correct. So I'll settle for C for Calcutta, both 1 and 2. Rashtriya Garima Abhiyan is something related to eradication. This is a basic, very basic. Eradicate the practice of manual scavenging and rehabilitate manual scavengers. Mission Indradhanush again is a very easy question. It is related to immunization of children and pregnant women. Swayam again is a portal where videos, educative, informative videos are uploaded. So that the students get quality access to education without spending much. So this is an initiative by government to increase the information base and the knowledge and help the students. Okay. So it is promoting affordable and quality education to the citizen. That is D. Okay. National Skill Qualification Framework. Okay. So a learner can acquire the certification only through formal learning. So this is not correct. Why this is not correct? Because it also includes the informal learning. Okay, that is something which is also taken into account. If you see the very provision of that, so informal learning is also taken into account in that. Okay, so an outcome expected from is mobility between vocational and general education. Yes, this is the beauty of this scheme, that there is a mobility between vocational and general education. So we will settle for B2 only, because here they have said only and formal. So question number 6, B2 only. National Career Service is an initiative of Department of Personnel and Training. No, this is factually incorrect. It is the Ministry of Labor. Okay, is launched to improve the employment opportunities to uneducated youth of the country. Do you think that career is important only for an uneducated youth? Career is equally important for an educated youth. So how can there be a scheme only for uneducated youth? So this statement is also wrong. This is wrong. And you have D for Delhi, that is neither one or two. What is the purpose of Vidyanjali Yojana? Okay, so this is actually a tricky one, because you see now they have given long statements which are incorrect in nature. For example, you just read this: voluntary monetary contribution from private individuals to improve infrastructure for primary and second. Why an individual will be asked by the government to give money to improve what you call infrastructure in primary school, when after the tax you take 4% health and education cess, then CSR may companies are contributing. So why private individuals? So eliminate 3. Now, to increase, to establish famous foreign educational institution. Do you think famous is a verb or famous is an adjective? So what is famous? How can we say that famous educational institution? Educational institution either can be on the basis of national ranking or international ranking. Famous is something which is more of a colloquial thing. So this is something where you can exclude the first and third. So I'm excluding first and third. I'll get 2 only. So the answer would be to increase the quality of education provided by taking from the private sector and the community. So it is 8 2 only. Okay, so that is something which you see the very important aspect related to that. That is in the sense ki the uh, private sector, why will private individuals contribute for infrastructure? So we'll settle for question number 8A 2 only. What is the aim of Unnat Bharat Abhiyan? This is again a very easy thing. So this is first, achieving 100% literacy. No, 100% anything 100% cannot be achieved for anything. We'll try. Okay, so many a time there will be 1% also left in the country. So developing human capital by allocating special funds for health. No. Connecting institutions of higher education with local communities to address developmental challenge through appropriate what you call this is appropriate technologies. This is a correct answer. So for Unnat Bharat Abhiyan, we will settle for B for Bombay. We'll settle for B for Bombay. Okay. So if you see, I wanted to discuss few what you call few other aspect also, which I have noted down related to the schemes and all. This is a 10-year. So this is one part of the previous year's question paper that is very dynamic in nature. In fact, I was going through some other. So although these schemes are important, but more important, you have to emphasize on those schemes which are in news. I have a list of those schemes which are in news. So those schemes are relatively more important. In previous year's current affairs, if you'll do Indian Constitution and all, then of course the questions would be repeated. But when it comes to schemes, usually you have to keep track of those schemes which are in contemporary news. So this is connecting higher educational institutions with local communities to address the developmental challenge through appropriate technology. So question number 9, we will settle for B. Recognition of prior learning scheme is sometimes mentioned. Enrolling the person in universities for distance learning, no. Reserving some skilled job, this seems wrong right at the onset. Certifying the skills acquired by trainees under National Skill Development Program, no. Answer would be certifying the skills acquired by construction workers through traditional channels. So question number 10, we will settle for A. Which of the following objectives of National Nutrition Mission? Again, you can work this by elimination. For example, eggs. Vegetarianism is practiced in many states. So how can a nutrition mission call for an egg? so we'll eliminate 4. Then it is an unpolished rice. This punctuality or this precision, these all things are vague in nature and you can directly eliminate 3. So I'll eliminate 4 and 3 and I'll get A, 1 and 2 only. Even by common sense, without reading this, you can say that poultry, eggs, and that too poultry, getting my not desi eggs but poultry eggs, so that is something which is an excluding statement. And unpolished rice, so these statements itself, word keywords also can lead to the elimination of the statement. I'll eliminate 3 and 4 only. What I get here is A, 1 and 2. The food safety standard replaced the Prevention of Food Adulteration Act. Bilkul sahi. FSSAI is under Director General of Health Services. No, it is actually an autonomous body, but overall administrative jurisdiction of Ministry of Home Affairs, not Director General of Health Services. So second statement is wrong, first is correct. So we'll settle for 12A1 only. With reference to Pradhan Mantri Kaushal Vikas Yojana, it is a flagship scheme of Ministry of Labor and Employment. Okay. Then if Ministry of Labor and Employment will provide skill development, then what will Ministry of Skill Development do? So answer first, so we will eliminate this. Is it not of Labor Employment, Ministry of Skill Development? So I'll eliminate 1. So 2 is common. So the only thing is to see, it aims to align the competencies of unregulated workforce of the country with national skill qualification framework. So it is something which is, it will impart soft skills and all. Both the statements are correct. So we'll settle for question number 13C. It will also, if you see some other schemes are also what you call in this particular sense, that if you see the provisions, there are some more schemes which have been added. See, previous years, the purpose of previous years is to prepare you for tomorrow. So those those aspects, these schemes which have been asked in the past may not be repeated, but those skill development and other initiatives taken in the recent times have to be kept tracked on. Okay, so I'll settle for question number 13C, 2 and 3 only. Now here, consider the following statement about particularly vulnerable tribal group. The moment I see 95, there are 75 PVTGs. So I will directly eliminate 3. Then we will get C, 1, 2 and 4. Now this is a very factual question. Particularly vulnerable tribal groups are in 18 states and union territory. There are multiple, for example, for recognition as a tribal community, certain what you call criteria is there. That shyness of contact, you have a distinct way of life, they have their own beautiful culture, different way of life. So this is for scheduled tribe. But primitive tribal groups, मतलब उनके कुछ और क्राइटेरिया, जैसे यूजिंग प्री what you call pre development, those agricultural practices are there, so they are relatively more what you call, when it comes to development, they lag on that. So they have been classified and there are 75 primitive particularly vulnerable tribal groups. So declining population is a criteria. 18 states is a correct statement. Irregular is in Tamil Nadu and Reddy is in Telangana. So this is also a correct thing. So I'll settle for 1, 2 and 4, that is C. Question number 14C. Now MP LAD is a basic factual question given in your Vision IS booklet also. It must be create durable assets. Yes, a specific portion must be reserved for SC/ST population and district authority must inspect at least 10% of the work. This is correct. This is a unique initiative where 10% has to be what you call inspected. And one of the basic quality of MP LAD fund is there, it doesn't lapse with the financial year, it is carried forward to next year. So it says it cannot be carried forward, so it is a wrong statement. So I'll eliminate 3. I will get 1 and 2 and 1, 2 and 4, and this is a correct statement. So I'll settle for D for Delhi, 1, 2 and 4. With reference to Ayushman Bharat, now this also, even if you don't know the scheme, you can easily eliminate it by what you call by common sense. Whenever UPSC gives a very high tech extra statement which is adding more and more adjectives, or statement which is too what you call too rigid in nature, like must adopted, higher levels of learning, very competitive, using the term very, or using the term 100%, or exclusionary, or emphasizing on it will remove all the, so all these terms which are too what you call far in nature, or they are too stretched upon, they usually are incorrect. Is say private and public hospitals must adopt it. If this is the situation, then all the hospitals in the country, in the mohallas, in the localities, in the colonies, they also must adopt it. which is an incorrect statement. And more important is, it says ki every citizen of India should be part of it. You must think that, are you a part of Ayushman Bharat, although you also are a citizen of India? So straight away you will eliminate statement 2, you get 3 and 1 and 3. So then it has seamless portability across the country. This is a correct statement. Every hospital will not what you call adopt it. So first is excluded, 3 is correct. So we'll settle for question number 16, B for Bombay, 3 only. Now this is army's operations undertaken by army towards upliftment of local population, including addressing of their basic needs. This is a factual question. Operation Sadbhavna, that is C for Calcutta, 17 C for Calcutta. With reference to Pradhan Mantri Surakshit Matritva Abhiyan, consider the following. The scheme guaranteed a minimum package of antenatal care services to women in their second and third semesters of pregnancy and 6 months post-delivery healthcare service in any government health policy. See the use of term any government health policy. So there can be different hospitals, and 6 months, this is a wrong statement. Okay. Under this scheme, private sector providers of certain can volunteer. Yes, private sectors can volunteer at the nearby. So we will settle for B for Bombay, that is 2 only. That is more of a factual question. 18B. With reference to Pradhan Mantri Sharam Yogi Man PMSYM Yojana, consider the following. The age group of enrollment is 21 to 40, which is blatantly a wrong fact. Age specific contribution can be made correct. Each subscriber shall receive a minimum pension of 3,003 is an absolutely correct statement. And unmarried daughters will not get the pension, but only wife will get the pension. So 2 statements are there which can be easily excluded. 3 is a correct statement and 4 is a wrong statement. So we have only 3 over here and 4 is wrong. So we will easily settle for 19 B for Bombay, that is 2 and 3 only. 19 B for Bombay, that is 2 and 3 only. Then you have NIF is an autonomous body of Department of Science and Technology under central government. This is a correct statement. And then it says initiative to highly advanced. Again, UPSC is using a very extrapolar statement. Highly advanced, 100%, excluding everyone, almost every time. So if they use those statements which are too rigid, too forward, or too stretched, then they are mostly, or they say ki they must adopt it. So each and every individual will do that. All these statements are a trick where UPSC wants to trap you by giving you too bold a statement which is actually a wrong one. It says NIF is an initiative to strengthen the highly advanced scientific research in India's premier scientific institutions in collaboration. This is a wrong thing, but it is an autonomous body of Department of Science and Technology. So we'll settle for question number 1. This is 2015 A, 1 only. Government of India established Niti Aayog to replace the Planning Commission. So D for Delhi is the correct answer. Which of the following are key features of National Ganga River Basin Authority? Again a factual question, but this is one of the most important authorities for the rejuvenation of Ganga River, which is holy, sacred, and also provides life to so many people because by providing so many water in multiple ways. So Prime Minister himself is the chairman. So first we will exclude where it says chief ministers on rotation basis are chairman. So we'll exclude 3. The only answer we get is 1 and 2. So river basin is the unit and spearheads the river conservation efforts at national level. National. It matches 1 and 2. So we'll settle for A, 1 and 2 only, 2016. With reference to prohibition of Benami Property Transaction Act, consider the following. A property transaction is not treated as Benami if the owner of property is not aware of the transaction. It is almost tough to prove that whether he is aware or not. You cannot just leave him because he says that he is not aware. So this cannot be a reason. Are liable for confiscation correct? Acts provides for 3 authorities for investigation but does not provide any appellate mechanism. There is an appellate mechanism. So first and third are absolutely wrong statements. We will settle for B for Bombay, 2 only in question number 4. Aadhaar cannot be used as a proof of citizenship. Aadhaar can be used is written. We all know that even a foreigner staying in India can get Aadhaar. Aadhaar has nothing to do with citizenship. So Aadhaar card can be used as proof of citizenship is absolutely wrong.
again there is an extra statement given. Once issued, Aadhaar cannot be deactivated by issuing authority. If Aadhaar is generated through fraud or illegal means, or it can be deactivated. This is a common sense that once Aadhaar is activated, it can never be deactivated. It is wrong. So both the statements are wrong, because Aadhaar is not a citizenship document and it can be deactivated in certain extraordinary circumstances. So both the statements are wrong. We'll settle for D for Delhi. Neither 1 or 2 in question number 5. The rule of law index, this is a factual question. Rule of law index is released by World Justice Report. Okay. As per RPA Act, to be eligible for appointment as a teacher in a state, a person would be required to possess the minimum qualification laid down by the concerned State Council of Teacher Education. No, education is in concurrent list and it is National Council of Teacher Education. First statement is wrong. In India, more than 90% teacher education are directly under state government. There are so many private schools, so this again is a wrong statement. So 1 and 3 is wrong, so we will easily settle for B for Bombay, that is 2 only. As per the RTI Act, for teaching primary classes, a candidate is required to pass a teacher eligibility test conducted in accordance with National Council of Teacher Education guideline, which is a correct statement. So we'll settle for 7B2 only. With reference to the provisions made under National Food Security Act, first thing you should know, first thing that is taught for National Food Security Act, it covers 67% of population, 75% rural and 50% urban. So it says only BPL. So first is an absolutely wrong statement. Okay. Now, pregnant women and lactating mother are entitled to take home ration of 1600 calories. No, this is again a wrong statement. So first and third is wrong. We will settle for B2 only, because the eldest women of the household of 18 years of above shall be head of the household for the purpose of issue of ration card. This is a correct statement. And question number 8 here in 2000, what you call this question that we discussed, the answer would be B for Bombay, that is 2 only. In context, which of the following would be considered as social capital? Social capital is harmony, love, affection, solidarity, fraternity among the members. So answer would be level of mutual trust and harmony in the society. D for Delhi. This is an easy question. Which of the following maternity benefit act? You know, in maternity benefit act, there is 26 weeks of maternity leave. Here they are giving 3 months pre-delivery and 3 months post. There is no such provision that only 3 months pre-delivery or only 3 months post. There is a flexibility. You can take after delivery, few days before delivery, and after delivery also. So this is absolutely wrong. One is a wrong statement. So enterprises with creches must allow minimum 6 creche visits. If 6 creche visits is not there, enterprises having minimum 50 employees. So again, this is a wrong statement. Women with 2 children get reduced entitlement. This is a correct statement. So question number 10, C for Calcutta, that is 3 only, is the correct statement. One common agreement between Gandhiji and Marx, this is very simple. Hind Swaraj you can read. Final goal of a stateless society. Marx also argued the same, that dictatorship of the proletariat and the final goal of stated society. So a stateless society. So we will settle for A. Aadhaar metadata cannot be, now this, consider the following statements. Aadhaar metadata cannot be stored for more than 3 months. No, cannot be stored for more than 6 months. So again, first statement is wrong. State cannot enter into any contract with private corporation for sharing of Aadhaar. Yes, this is the correct statement. Aadhaar is mandatory for obtaining insurance product. This is not mandatory. Okay. Aadhaar is mandatory for getting benefits from CFI. It is desirable, but nobody will be denied benefit only because he doesn't have Aadhaar. So 3 and 4 we will exclude. First we will exclude. 2 is the right statement. So we'll settle for B for Bombay, 2 only. Right to city is an agreed human right and monitors the commitment made by each country. So okay, let's see. Now it says monitors the commitment. It is not possible for the right to city to monitor the commitment in 193 member states of UN, and then it's 100 cities in so many countries. So it is not a correct statement. It gives every occupant the right to claim public spaces and public participation. Yes, this was right to city, and state cannot deny public services to the unauthorized colonies also. You have to provide basic services. So 2 and 3 is correct. We will settle for D for Delhi. Question number 13, D for Delhi. Mitakshara was civil law for upper caste and Dyabhaga was civil law for lower caste. This is wrong. That was both for both the castes. So this is absolutely wrong statement. And in Mitakshara system, sons can claim right to property during the life of the father, while in Deyabhaga system after. So this is a correct statement. Mitakshara system deals with matters related to property held by main members only of a family, where Deyabhaga system deals with related to by both male and female. There is no such distinction in Deyabhaga. So this is a wrong statement. Third is a wrong statement. First is a wrong statement. So question number 14, second statement is correct. So I'll settle for B for Bombay 2 only. 21st February it is declared to be International Mother Language Day for UNICEF. Why United Nations Child Emergency Fund will declare language? It will be declared by UNESCO. So this is blatantly wrong. And the demand that Bangla has to be one of the national languages of Pakistan, this was raised in their constituent assembly, of course. So this is B is a correct statement. Question number 15, B2 only. With reference to India, consider the following statement. Judicial custody means an accused is in the custody of magistrate and such accused is locked up in police station, not in jail. In fact, in judicial custody, police cannot touch the accused without the permission of the judge, and he goes to the jail, not to the police station. This is absolutely wrong. During judicial custody, police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. Absolutely correct statement. Unless he is given police custody. So in judicial custody, the officer cannot access the accused without the approval of the court in this case. So second is the correct statement. We'll settle for B2 only. With reference to India, consider the following. When a prisoner makes out a sufficient case, parole cannot be denied to such prisoner because it becomes a matter of right. Do you think parole is a right? Parole is given after certain behavior, certain extraordinary situations in the family or any wedding or any such thing, or some extraordinary situation. It is not a right. It is a discretion of the state. So this is wrong. State governments have their own prison rules. You know, entry 4 of the state list is prison. So of course prison, the state government have made their own rules. Then erstwhile for remission also section 432 of CRPC, 433A of CRPC and 435. Okay. So of course it is within the state government. So second is the correct statement. To question number 17 will settle for B2 only. Bharat Ratna and Padma awards are titles. You know, Article 18 clause 1 says that Indian state shall not award a title except military or academic. Then how can Bharat Ratnas and Padma award can be a title? It is not a title, it is an award. And this was upheld by Supreme Court in Balaji Raghavan case. So first statement is wrong. Awards were instituted in 1954 and were suspended once, no, twice. In 1978-79, then in what you call 77-78, after 77 technically, 78-79, and in 93-97. So during Moraji Desai ji's government and 93-97, they were discontinued 2 times. So this is also a wrong statement. Number of Bharat Ratna given in an year is 5. No, it is 3. So they are asking how many statements are incorrect. All 3 statements are incorrect. So I'll settle for D for Delhi 1, 2 and 3. At the national level, which ministry is the nodal agency to ensure effective implementation of the Scheduled Tribes and other traditional forest dwellers recognition of Forest Rights Act? This is a very wonderful law where their rights are recognized. For example, you have the provision of issuing pattas. Then those people, 13 December 2005 has been taken as cut-off date. Those who are living for 3 generations, they will be given. Then what you call, there are provisions to secure their rights. There is appellate mechanism also within the law. Okay, so this is Ministry of Tribal Affairs. So 19D for Delhi. Coal Control Organization, okay, it is a major source of coal statistics, correct. Monitors the progress of development of captive coal, yes. Hears objections to the government notification, yes. It ensures that coal mining companies deliver the coal to the users in prescribed time. Do you think an organization in Delhi or different parts of the country has the capability to go and check every coal mine that whether coal is being delivered or not? This is an impractical expectation. So fourth is a wrong statement. We will settle for 1, 2 and 3. Question number 20A. T-Board of India. T-Board is a statutory body. Okay, chalo, you may know this or you may not know this. But here it says that the headquarter of T-Board is Bangalore. Bangalore, South India is known for coffee. Darjeeling area is known for tea. So how can the board of headquarter of T-Board shall be in Bangalore? Of course, it will be in Kolkata. So here the very statement third is wrong. You will eliminate third and then fourth is a common in both. So you will see now first, of course it is a statutory body. So we will, and it is not attached to Ministry of Agriculture, Commerce. So this is a wrong statement. Of first and fourth are correct statement. We will settle for D for Delhi. Now statement 1. In India, prisons are managed by state government with their own rules and regulation for the day-to-day administration of prisons. Yes, correct. Because entry 4 of the state list, you have prisons. In India, prisons are governed by Prisons Act 1894. Recently, you should read for means also. Ministry of Home Affairs has released Model Prison Act. That you should know. Okay. Model means the states can follow so that there should be uniformity across the country, which expresses, matlab they have released a model law, you may follow it. So in India, prisons are governed by Prisons Act 1894, which expressly kept the subject of prison in the control of provincial government. This is a correct statement. So both statements are correct, and statement 2 is the correct explanation. So 23A for apple. With reference to Home Guard, we know one thing for sure, Home Guard comes under the state government. So first line, that Home Guard are raised under the Home Guards Act and rules of central government, this is wrong. They maintain, the role of Home Guards is to serve as an auxiliary force to the police to maintain internal security, absolutely correct. And recently some border wing Home Guards battalions have been raised in states like Punjab, which share border, and in Northeast, so that they should keep a track on the movement and infiltration. So second and third is correct. Easily we will settle for B only 2. Question number 24, B only 2. Now this was a tricky one. This is a factual question. No concept here you should know that unauthorized wearing of police or military uniform is a violation of Official Secrets Act. Celebratory gunfire which can endanger personal safety of others is violation of Arms Amendment Act 2019. Misleading or otherwise interfering with a police officer or military officer when engaged in their duties, this is not Indian Evidence Act. So this statement is wrong. First and third is correct. So we'll settle for only 2. Question number 25 here, only 2. B is the correct answer. What is the duty of Chief of Defence Staff? You know that Chief of Defence Staff is there. He is the principal military advisor to the Defence Minister. He is a permanent chairman of Chief of all Staffs Committee, but he doesn't exercise military command over 3 service chief. They function within their autonomous domain that is given. So he will not exercise control. So we will, 1 and 3 is correct. We will easily settle for D for Delhi. So question number 26, D for Delhi, 1 and 3. Here also they have given a confusing statement. The only matching that is correct is major in army is equal to squadron leader in Air Force and lieutenant commander in Navy. So only 1 is correct here. So that is 3. So we will settle for question number 27, D3 only. This was a factual thing. D3 only. Consider the following. Under Article 342 of the Constitution, scheduled tribe is recognized through a presidential order. Amendment can be done only by the Parliament. States cannot decide. Recently, Supreme Court has allowed the states to go for sub-classification. But for getting a new community included in scheduled caste or scheduled tribe, state will make a request to center. Center will do that through a parliamentary amendment and presidential notification later. So president will issue a notification after parliament has passed an amendment under Article 341 for scheduled caste, 342 for scheduled tribe. It says it is the government of state who recognizes and declares any community as a scheduled tribe. Absolutely wrong. It is the government of India. Okay. Parliament passes an amendment to the presidential order of 1950 scheduled caste, and a president modifies subsequent to the amendment by the Parliament. So this is wrong. A community declared as scheduled tribe in a state need not be so in other state. This is quite common. There are communities which can be scheduled tribe in a state, may not be in other state. This is right. So we will settle for B for Bombay 2 only. So these were the questions which we have discussed. Schemes may basically, previous year's question is important, but more important is to keep track of those schemes which are in news, and this is more of a factual thing where students usually make mistakes, so you have to be quite aware about the same. Okay, so this was the discussion of polity and governance for what you call 10 years that we were discussing. Thank you.